Thanks to everyone who's joining us. We'll let folks get on. We are live streaming on YouTube. And we're just waiting for a few more folks to join us. Hey, Kevin, can you go into the Teams meeting?
I'm sorry, what was that? Oh, in the Teams? Yes.
Yeah, thank you. I think we're just waiting for a couple more people to join and then we'll get started. Okay, well, since we are after 1:30, I'm gonna stop sharing my screen so everybody can see each other. So thank you for joining us for the third Ocean Shores Rule Advisory Committee meeting. We I hope you all had a very happy new year, and we appreciate you coming back to help participate in this process to develop ocean shore permitting rules. We'll start with a round of introductions just to make sure that I know we've had a couple meetings, but it's been a little bit, and make sure that we all remember who's on. So I'm Katie Gauthier, Government Relations and Rulemaking and Communications for OPRD, and then we'll just do popcorn style. So I see Laurel is next to me. Laurel, if you want to.
Good afternoon, everybody. I'm Laurel Hillman. I work for Oregon Parks and Recreation Department. I'm the Ocean Shore Resource Coordinator, and I'm going to choose Megan.
Hi, I'm Megan Wengrove. I'm an associate professor in coastal engineering at OSU, and I'll choose Tyler.
Hey guys, I'm Tyler Blanchette. I'm the Ocean Shore Permit Coordinator for Oregon State Parks. I'll choose John O'Leary.
Tyler, I'm John O'Leary. I'm the Senior Planner for Lincoln County, and I will choose Charlie.
Hey, Charlie Plavin. I am the Senior Policy Manager for Surfrider Foundation, and I will go to Felicia.
Hello, Felicia Meta-Schultz. I'm the Coastal Hazard Specialist with Oregon State University Extension and Oregon Sea Grant. And I will pass it to Nancy Taylor.
Thank you. Nancy Taylor. I'm the Waterway and Habitat Incentives Coordinator at Oregon Department of Fish and Wildlife, and I will pass it to Diana Turner.
Hi, I'm Diana Turner. I run a grassroots group, activist group in Cannon Beach called Friends of the Dunes. Oh, I'm supposed to pick someone. Okay. Geez, well, Katie, have you gone?
How about Allison?
Okay.
Hi, I'm Allison. I work with Oregon Parks and Recreation Department in an administrative capacity. Thank you. How about Andrea?
Morning or good afternoon. I'm Andrea Hansen. I work for OPRD. I'm the Central Operations Resource Manager, and I manage the Ocean Shore program. I'm not sure who's left.
Jonathan?
Jonathan?
Good afternoon, Jonathan Allen, coastal geomorphologist with the Oregon Department of Geology and Mineral Industries. And I'm not sure who's next, maybe Rhiannon?
Thanks, John. I'm Rhiannon Bazor. I'm the Coastal Shore Specialist with the Oregon Department of Land Conservation and Development. And let's see, Jackie, did you already go?
No. My name's Jackie. I'm a project manager with Surterra, formerly Earth Engineers. And happy to be here.
Cameron.
Hi, I'm Cameron LaFollette. I'm the Executive Director of Oregon Coast Alliance, which is a land use watchdog organization.
I think that leaves Kevin.
And I'm Kevin Herkamp. I'm the Ocean Shores Program Coordinator with OPRD.
Anybody else that we didn't go? Okay, great. Well, thank you very much. Next, we were going to move to just go over if there were any questions or things that had come up since meeting 1 and 2. I don't know, Kevin, if you had anything that had come up that you wanted to share.
Charlie, I think you sent in a comment, I believe, and I think that was related to one of the earlier meetings. I don't know if you wanted to talk more about that or not.
I think some of that I reflected in the Google Docs. I've been trying to catch up a little bit on now that we have a document we can kind of contribute to. But yeah, the notice on the appeal process or lack thereof kind of struck me. And I'm also experiencing it as we speak. So I was curious why, or it doesn't seem quite correct to me that there isn't a notice process for an appealed permit for affected parties or those that were interested or even commenting on the permit application in the first place. So maybe you could shed some light on that, or am I missing something?
Katie, you want to take that one since you're more familiar with the kind of the overall appeals, or because I don't necessarily have an answer for you, Charlie. I don't.
It seems a little contrary to like public process to me that we would that application that could have been argued by many an interested party could be having an administrative appeal in a hearing without noticing anybody who was an interested party. I couldn't find a rule that required the agency to notify that in your previous rulemaking. The previous rule that I guess it was during the last meeting that you guys were reviewing.
Yeah, and it's not. I'll be on. It's not in the current rules or the proposed rules, so that is something that could be looked at. I don't know, Katie, if you have any background on.
I don't. It's something we can look into, and if you have example language, it would be great. I think the appeals we were looking at would follow the APA if they go too far, but if you have example language you want us to look at.
Yeah, there was a couple. I mean, and there's another area where it's like the failure of the department to notify an interested person won't change the time frame for any hearing. That sounds like an opportunity for outright exclusion if the wrong person was in charge. So I do. There's a couple of areas like that where I don't think we're being consistent with goal 1, and we ought to be ensure that we're like following the right public process. I would probably turn it to your DOJ to find the exact language. I'm happy to offer some ideas on that, but I'm sure it's reflected elsewhere.
Yeah, we can look into DSL or DLCD language as well. But just if you have any suggestions.
Sure. Yeah.
Diana?
Hi. Yeah, just to piggyback on what Charlie was saying, I also am very concerned about the lack of transparency and share out around appeals in Cannon Beach. You guys, OPRD denied a permit in November, and that's how its status stays on your website. And I happened to stumble upon some information on a Facebook site saying that there was an appeal in process and there was going to be a site visit. And the applicant was encouraging the community to turn out and support them in their attempt to, overturn your decision, OPRD's decision. And so I went to that site visit, just curious, how does this all work? How is it handled? I asked at the end, and that was really handled very well, and I thought it was great for all parties. The administrative judge said, "See you guys tomorrow in Tualatin," or some such thing. I asked if there was an opportunity to view that remotely, and the attorney for the applicant spun on her heel and said no. And again, at that point, I just wanted to observe this process to understand it better, seeing that possibly in the future it might be something that I'm involved in. And as I was walking out, I asked the judge, if there was a way to call in, because it seemed more like it was a technology issue rather than a decision that it can't be viewed. And he shared that that it was up to the attorneys to decide that, and that he was not aware of any way to share communication. I asked if I went to Tualatin, would I be allowed into the hearing? And he said, it's up to the attorneys. And then I said, so how would I go about seeing about that? And he's at that point said, I'm uncomfortable talking to you any further. I'm going to stop this conversation. I told him, I understand I'm jumping into this late. How about we just set this whole process aside, the specific process aside? Can you tell me administratively how this process works? And he said, I cannot. And I said, how would I find that information? And he said, I guess you would go to our website and find a name and start calling until you find somebody who can talk to you about this. And I said, is this not a public process since it involves the public shore? And he said, I'm uncomfortable with this conversation. I cannot talk to you any further. So that, like I said, that wasn't my hill to die on, this application. I'm still receiving updates on Facebook about how the applicant felt it went and next steps. But it is deeply troubling that the person who's running the process cannot explain the process administratively or direct me to somebody who could and is uncomfortable talking to me about it. So
I want to make sure that as we are moving forward, because that's ongoing litigation, that we're looking at the administrative rules and not going through the ongoing litigation.
Absolutely.
Because,
absolutely. I agree. I understand that.
Yeah.
So I understand that I'm sharing my experience and what I learned about that. So I don't care to discuss the particulars of that case. I'm saying that when there is an appeal, that's not being communicated. And nobody can explain to me how this process works. And that is troubling. So I agree with the issues that Charlie brought up. I think that there needs to be a clear process so that the public can engage at the appeal level.
Okay, so we'll go back and look and see what appeals language can be added, or what what other agencies are doing or specifically needs to be. John, did you have something?
Yeah, I just wanted to comment. I mean, from experience, I've handled a lot of public hearings and legislative processes at the local level. And the theory for noticing is very much the same wherever you are. There's that initial notice that goes out to, basically all affected or interested parties, depending on the type of, process you're following. It goes, it's just broadcast publicly. And then if you reach a point where you have an appeal, and I'm just gonna really give you the superficial theory part. There's nuances, but an appellant takes that legislation or whatever the application is, and they're saying, look, I think you erred. This agency made some error in approving it or disapproving it, and I want to challenge that, that decision, so that it's not that it's not accessible to the public, the continuance of that process, but you are talking about a particular party that's now appealing a particular decision of an agency to the next higher decision-making authority in that matter. And I'm not saying you shouldn't notify people that this process is taking place, but really it starts becoming a matter between parties at that point. And so it doesn't surprise me that there isn't actually a requirement to renotice all parties, affected parties, of the appeal process, because if they didn't object to the decision or the legislation in the first place, or they didn't take an interest in the appeal of said decision or legislation, then I think there's an assumption that they have no interest or stake in that action, that appealing action. But that doesn't mean that they don't have that doesn't mean that they're not affected by it. It just means that they weren't interested in that part of it. But I think the other component to that, and this is this is a little bit of a structural flaw. Somebody can appeal a decision, and somebody may have got a notice that some decision was going to be made. They may or may not have been part of the hearing process. But the appeals usually occur after the decision. So maybe by the time they left the hearing or whatever, they just kind of forgot about it. Then this appeal gets filed. They probably would never know about it. So that's just something that happens within the system. And there are some mechanisms that each agency local will try and do to make sure that people get notified of it. But yeah, it does happen. It's not deliberate. It's not an act of excluding the public per se. It's just, it happens to happen in the midst of very bureaucratic processes. So anyway, I just wanted to throw that out there. And I don't disagree with Charlie or Diana. I mean, there's a need for people to be aware of what's going on and definitely getting notified. But the process is a little cantankerous sometimes. I'll leave it at that. So I just wanted to throw that out there as kind of a little bit of a fence post to hitch to there. So
well, and once it goes into the administrative hearings process, then it's outside our scope of the agency, but we can look at see if there's a notification that other agencies are doing, or what we
I think on a quasi judicial decision, those ones are a little tricky too, because you have an area that is affected, and all the people that were in that area that got the initial notice of the decision being made, they receive that. I don't know whether they ever receive a notice of an appeal, or the outcome of said appeal. If the appeal was successful and the decision was reversed, I guess it's possible that people who thought something was decided weren't necessarily notified that that decision was reversed. But being a quasi-judicial process, it seems that I think that in theory that would only affect a particular property owner, a particular applicant. That applicant would be riding through the entire process from start to finish. So their neighbors may or may not know that maybe their permit was appealed and denied, or they succeeded in getting it. And that, I guess I can see, maybe you thought your neighbor wasn't going to get riprap, and then next thing you know, your neighbor got riprap because nobody told you that they said successfully appealed the decision to deny that permit. I can understand how that would be frustrating or aggravating. So anyway.
Charlie, go ahead.
Yeah, I need to respond. I think I think we're conflating two different things, which is noticing everybody every time anything happens and noticing people who were party to an argument that supported the agency's final decision. For example, in the case of Diana, she had people and was going to public hearings and engaged in a permit process that concluded with a decision that she supported, um, only to find out that somebody had appealed that, the applicant had appealed that, and she was excluded. There was no way that that party would have ever known. And so that's not the same as saying everybody in the world should know about that this has been appealed, but absolutely people who have a vested interest and have showed and demonstrated a vested interest and are on the public record, um, those individuals you would think would be at least noticed of the fact that there is an appeal happening. And in some place in that administrative process, whether the agencies are part of that or not, which they're not, there should be some understanding of how that's argued. Otherwise, it's a loophole to exclude the public. And those, it's just like, if I don't get what I like, I'll just go around this and get an administrative judge to tell me. And don't worry, their arguments won't matter because they won't be in the room. So I think that to me is what I'm trying to rectify and understand. And in many cases, I think that it might behoove the agency to have individuals that were party and interested, invested, to be part of the administrative hearing, or at least privy to provide some materials to the judge.
Okay, well, we will go back and look and see what we can find from other sources to see if there are different options. John, did you have?
I don't disagree with you, Charlie. It's if you're a party and you've expressed an interest in a decision, and there's usually I can't speak for every agency of the state, but it's not uncommon to have a process to take somebody's information. You have the opportunity to give somebody some information, the jurisdiction, say, hey, I want to be notified of continuing decisions and actions on this particular whatever application or process, and then that should open the door so that you're getting those notifications. I don't know. I mean, I guess I would say if it's a proactive process where you as an interest party have to actually tell said agency, hey, please keep me advised. I don't know. I don't know if that's reasonable or unreasonable. I think it's reasonable to tell the agency, hey, please keep me advised on what's happening with this application. That way you're getting decisions of appeals or anything like that. And I don't know if the state, I don't know when and where the state does that or doesn't do that, but that's a mechanism. And at least I've done that at the local level where somebody's come up and said, well, I want to know more about this. And well, I'll make sure you get notified, and they're on a list for that particular action. They get emails or whatever. So that is done and it can be done. But I agree with you. No one, if somebody had expressed an interest, especially if they'd submitted, I mean, I don't know, if they'd submitted testimony and for or against something, yeah, I would expect to be notified if something changes, especially if I have expressed that interest to be notified. So I agree with you on that.
Yeah, it seems like LUBA requires this in their appeal process, right?
Yes. Yeah,
Like,
no,
so
that's correct.
Why would this be any different than that? I guess is my.
I don't know. I agree with it's a good process to have, and I support that. Yeah.
Well, are there any other from the previous meetings outside of appeals that we wanted to go over before we move on to enforcement?
I was going to say, given the length of this conversation, maybe not, but I have provided some comments and things that I would at least like the opportunity to discuss with the agency or the RAC at some point. I don't want to go backwards, I realize, but I'm also just trying to hang on to this process as fast as I can because it's like a plane flying through the air and is costing us a lot of time for the next few weeks.
Very much so. We'll do enforcement and then we'll make sure that we set up some time each meeting to go over different pieces. So, Kevin, do you want to start with the background on enforcement?
Absolutely. Follow kind of the same pattern I did the last meeting. I've got a presentation here that should be in front of you now. And so basically, I did send sent in the packet was a summary statement, which I'm going to kind of go through that same document, but maybe not in the same details. I'm trying to kind of look at things share them a couple different perspectives. So hopefully you've had a chance to look at that summary statement, giving kind of the background, but really the overarching piece is this is going to be a kind of a full rework of our Division 80 and taking all the stuff out of Division 20. But if you have a chance, follow along with the version of the rules, and I'm not going to go through it line by line like we talked about before. I'm going to go through it kind of section by section. But before we start on that, I wanted to give you all kind of a little bit of background on where we stand with the rules and what we've already done. So I've kind of have two column table of contents here and what we've worked on them. So we've been working in Division 20. We did the scope and purpose for the program, with the application, kind of the review process, timelines, the emergency authorizations, amendments, extensions, where the fees go and appeals. So we did work through those. The kind of next substantive section will be the application requirements, and then we'll get in in end of January, early February, we'll get into most likely the more substantive sections of the rules. But for this meeting, we're going to jump over to Division 80, and the plan is to go through the entire division. This time it is really kind of its own standalone, and I apologize I wasn't able to get some of the other sections cleaned up enough for you to take a look at them this week. So I'll be working on that as we move into the next couple of RAC meetings. So here's where we sit. One thing that I do want to kind of show and share, as you saw in the summary statement, is this version on the left is really probably maybe a little over dramatic, but it trying to kind of show between the two processes. So currently our enforcement rules are split between both Divisions 20, which is our permitting standards, and Division 80. A very high level Division 20 kind of covers violations of permits, but then Division 80 is civil penalties for public nuisance. Well, in reality, a violation is, per statute, a violation is a public nuisance. So there's a lot of duplication because you basically have to look in statute, Division 20 and Division 80 to put things together. You end up with a lot of these weird, like, what is our actual process and what should I do at any given stage? And pretty much all of these yellow lines are something that could happen along in there. And quite frankly, it's confusing for us. It's confusing for applicants. And so what I am proposing in Division 80 is really more of a lineal process. This is based on other programs, in particular Department of State Lands. And looking at this as really more of how the reality of enforcement happens, where we get a complaint, we do these investigations. Once we get in there, if it's something that needs an emergency action, we issue a cease and desist order, or we issue them kind of I'll call it it's an early notice. Hey, we found something going on. Please don't do it anymore. If you're planning on it, we need to talk to you, that type of stuff, getting that connection. And then we go into a more detailed investigation. And from that, hopefully we move down. You see this gray arrow kind of behind, we move linear down through what we would call a consent order, which is a cooperative agreement that we work with the landowner to resolve the violation, and hopefully amicably we all walk away with the beach protected, with the lowest level of enforcement action that we need to take. And ultimately it's all about protecting the beach. And if not, we have a couple other options then, right? One is we can just, if there's something was done but there's really nothing that can be done to restore it, or no further action, we may issue what we would just call a notice of violation, basically documents that, hey, here's what you did, here's when you did it, here's kind of what is next. Maybe there was a civil penalty that we're waiving, something of that nature. They have the opportunity to appeal it, but it's more of we're putting you on notice. And then if you screw up in the future, you might have some additional ramifications. Or there's a proposed order which is really more of the department telling you what you need to do to resolve the violation and by when, may include a civil penalty. But it's really going to be more of that tool where if you're not cooperating, we're going to tell you what the expectations are. You do have the opportunity to appeal it. And then all of these move to a final order. The difference about a consent order is, again, the applicant or responsible party is agreeable. They'll sign the document. It goes to a final order. These other two documents do have the opportunity for them to appeal the stipulated facts, which is also known as the notice of violation. And so it's really kind of all three of them do have a notice of violation built into them. It's really saying, and here is what happened. So it's a much more linear process is what I'll be going through today. So hopefully that flow makes a little more sense on what we're looking at. And then, so as we're looking at the rule language that I put out in your review document, the first section is the powers of enforcement. Really, this section is based on a statement that's already currently in our Division 20 rules, which basically says, hey, it's reiterating something that's in statute that says we have the ability to go after these enforcement actions if you don't have a permit or you do something outside of a permit or permit condition. And it's also, this section is clearly defining that a violation and a public nuisance we use them interchangeably, basically. And so our statute does use the term public nuisance. And so we really kind of want to make sure we're equating that. So I did have a new section that also made it much more clear of what a violation can be. There are a lot of little nuances that go into that. And so it's not, yes, the current language has some more broad terms if you do it without a permit, outside the conditions in a permit. But there's also some other elements that are more nuanced to that where you might misrepresent some factual matters in your application and get a permit based on that. Well, in that case, your permit is really null and void. So that would also be a violation if we're able to go back and say that. So it helps clarify some of those types of things that are maybe some more nuanced aspects. Charlie, go ahead.
Yeah, can I just ask a question? Are we talking about as related to all types of activities on the ocean shore? Are we
all
are we still
construction?
in
It would
this permit alteration world, or that is the intent?
Yes.
Because I'm
That's all
thinking about all
alterations.
of the erosive forces and exposed septic tanks and crumbling concrete and all these other things that kind of are less related, maybe. And I'm just and I know where the powers begin and end, and that has been challenging with respect to nuisance in the past. So can you provide some context on that?
So if I'm getting your question correct, you're asking more about what happens if something ends up on the ocean shore, not.
Yeah, there's intentional activity.
Yeah.
And permitted and non-permitted intentional activities, and then there's I'm just curious. I feel like one of the challenges we've always had in identifying where the authority of parks begins and ends with a public nuisance or endangerment of the public on the ocean shore. Is that the county's responsibility, or is that Oregon Parks and Recreation's responsibility? To me, right now, this is kind of where that question might be answered or not. And I see John smiling because I know which direction he'd like to point the finger. And I'm sure, Kevin, I know which direction you'd like to point the finger. But I do want to know, are we talking or addressing any of that kind of stuff here or not?
And that's a really good catch, Charlie. I think, writing that list, I wasn't necessarily going through that exercise. I think as an agency, we've always reacted as if something ends up on the ocean shore and it's material that shouldn't be on the ocean shore, then that is viewed as an alteration. And so I think that's a really good point to clarify that, because I think there is, as you know, along these projects, there's that gray line between what is the local jurisdiction and what is ours. And I would say if it's something that's starting to be exposed and is potentially on the ocean shore, then we're hoping the local jurisdiction will step in, and we can also provide some notice to the landowner saying, hey, it looks like this might be a problem and might end up on the ocean shore. And by the way, if it ends up there, you'd be responsible for it. But you're right, the rules don't currently call out that I'll call it these unintentional alterations. And I think that is something that could be clarified, because we do get a lot of different things, whether it's foundations, houses, septic tanks,
Yeah, there's a lot of flavors.
upland seawalls that get eroded, and or planter beds that are now on the ocean shore. So yeah, there's a lot of those things. So I think there could be a way of covering that.
I mean, I think there is law and statute that allows a lot of enforcement in this space, but actually putting that to the rules would be helpful.
Yeah.
Because I think that's where we get in this chicken or egg situation. Sometimes we're like, well, we got to wait till that thing falls on the beach and then we'll call it a problem. Maybe that's not quite right.
Okay.
Looks like Rhiannon and Cameron.
Okay.
Thanks. Yeah, I would agree. I think that's something that we get calls fairly regularly about, that we have to then redirect to OPRD, whether it's debris that's on the beach from, removing vegetation that they either do or don't have a permit for, or people asking, my neighbor's house is about to fall over the cliff. When it does that, whose jurisdiction is that and whose responsibility is that to clean up? So I think having that be as clear and explicit in the rules as possible would probably be pretty helpful.
Cameron?
Yeah, I on that same point, a year and 2 years ago, I got a frantic phone call from someone in the Lincoln City area about a large styrofoam block that apparently was like a floater off a dock that had come from who knows where and was lodging itself on the inner beach around Siletz Bay, not the outer beach. And I called OPRD by way of whose responsibility is this? And it took a few calls, but it was also right before a holiday. And when I finally got to the right OPRD person, they said, it's not our responsibility. And I said, really? So where will I go to how to get this thing off the shore? And they said, well, call the county or maybe DSL. So I tried the county and they said, nope, not us. So I tried DSL and they said, well, if it's on private property, it's not us. But if it's on public property, then it probably would be. And they worked with the county to find out that the block, which was meantime shedding little styrofoam, what's the right word there, nubbins, on the beach and starting to erode, was on public property, and DSL eventually contracted with someone to get the thing, which was very large, off the beach before it disintegrated and caused a real mess. So that's just an actual concrete example, so to speak, bad metaphor, sorry, of what could we put in the rules about the kinds of things that are going to land on the beach that people are going to call about. I got also a call once about mink carcasses on the beach, and the person had called OPRD and was told it wasn't their responsibility. So having some kind of language in the ordinance, in the OARs about coordination with other agencies or where the flow of responsibility will go would be helpful for everyone.
And thank you. And I know internally we do have some guidance about marine debris. Fortunately, not all of our staff kind of know all the content that we have a few people that deal with it all the time and know. And so that may have been an issue. I'm not familiar with the exact situation yet, but that may have been, a scenario if kind of meeting the right person or talking to the wrong person at the wrong time. But you're absolutely right. Those are things that we need to have clear in there, because there are multiple agencies that get involved, depending on the type of marine debris and the location. And so, yeah, there's a lot of coordination that can happen for some of these things that seem like they should be pretty simple.
Yeah, and it happens especially in this particular case because it was on an inner beach rather than outer beach. It was a little bit more complicated, but in my limited experience with marine debris, it usually comes down to the local jurisdiction, whether a county or a city maybe, or OPRD or DSL, or some combination thereof. And it would really be nice to have that sort of chain of responsibility or mutual working on things set out a little more clearly so people know where they should be going at least.
I'll just jump in quick and say we did this years ago when the tsunami debris started coming in. We also lost some docks out of Charleston that landed up on Lighthouse Beach and became a parks problem. So as it relates to marine debris, there's a marine debris action plan for the state of Oregon that was in the process about to be updated again. As far as marine debris goes, though, I think we're kind of running down a lot of different other areas now. But marine debris, there should be in the action plan, the state's action plan, the direct sort of exactly what Cameron's asking for, a flow chart of DSL's acting on this one probably because it was, on the waterway and not on the open beach. Otherwise, that would have been OPRD in collaboration with a local partner. But that's spelled out. And some of that's also kind of mirrors our like oil response plan stuff, if you think like how the agencies coordinate and who are responsible. But that might be something to revisit, at least for marine debris. I think what some of the stuff I was thinking of was more terrestrial, direct, adjacent, kind of like the stuff Rhiannon was bringing up. But Cameron's point is good that we probably ought to have better staff education on how to respond to those things.
All right. Thank you. John, did you have something to add?
Yeah, I just wanted to comment that it's almost always multi-agency investigation when it comes to things that are interfacing with some water body in the shore somewhere. So there's a private property element, there's a county or city element, there's DSL, there's OPRD, and the number of agencies can expand pretty quickly. Oregon State Police gets involved in certain matters associated with DSL. I don't know if that happens with OPRD ever, but all sorts of agencies will be involved in an investigation process. And to Charlie's, I think maybe point, there is a phase where all the agencies are looking at each other, essentially trying to determine who's going to address said issue. And I know for a fact that sometimes that goes on for a while, and that happens. I imagine there's ways of developing a flow chart for how you move through a process where you have some issue and you ultimately find the agency that's responsible for addressing said issue. And I bet it's going to come down to a county or a city quite often. But then it's always a question of jurisdiction. So does that city or that county have the jurisdiction to go onto the ocean shore, address said problem, and resolve it with whoever it is that is perhaps creating said problem? And those are things that have to get worked out before a city or a county or any other agency for that matter is going to take any action. So I know that flow chart, first of all, I think it's a great idea, or however you structure a more efficient way of finding the responsible agency. I think that's a great idea. I'm also just going to point it out because of the varied types of issues we're talking about. You're going to run into one eventually that no agency is going to ever touch. And for a lot of different reasons, it takes a long time to finally get somebody to step up and take responsibility, so to speak, of how to resolve said issue. I've had numerous issues like I've been part of numerous problems like that in my career at the local level, where it took a long time before somebody decided they had to be the responsible party as whatever agency to deal with it. So I know that's frustrating, and it's frustrating to tell people, but it is actually, that's the issue. And if somebody's septic tank detaches from their house because the ocean shore receded that year, and now their septic system's essentially out on the beach, there's a county involvement in that, because now it's an EHS matter, and we're talking about how we restore this person's septic capacity and those types of things. And I imagine there's going to be other parties involved, including homeowners and insurance companies and et cetera. And it takes a long time to resolve those. So and OPRD absolutely has jurisdiction on the ocean shore, but and please correct me if I'm wrong, that jurisdiction doesn't make other parties that have to act move any faster. Sometimes you still often have to wait for a county to deal with the EHS issue or an insurance company to do whatever they got to do before things move any faster. I just want to throw that out there. So.
All right. Anything else on this first section? Okay, so we'll go to scope and purpose. This was second section in there. Most of this is based on our existing rules. And one thing I should point out, and I left it on this version for your benefit, I have some yellow highlight on the document I shared. Those are existing rule citations. And so part of it, because this was such a merging, I wanted to show where I was getting this information from and making these kind of combinations. And so in this one, you'll see that there's portions from Division 20 and Division 80, but effectively they said the same thing. So just kind of pointing that out and how this was a little bit of an exercise. But basically, this had kind of sets out the three components for our enforcement process, which is we want to resolve the violations. Again, going back to our main prerogative of protecting the ocean shore, we need to recover costs from basically our action, but also any of the damages that are out there to the ocean shore. And then timely compliance is the other aspect of really getting these things resolved as fast as possible is the best thing, that best course of action we can have. Because I know definitely when we deal with enforcement actions, a lot of times there's a tendency from the responsible parties to drag it out for whatever reason. Either they get what they put out there for a longer period of time, or the longer they wait, the longer they can go to a plan B. And so we really, as a state protecting the beach, we want to try to get those resources protected and any access issues or whatever restored as quick as we can. So any questions on scope and purpose? Okay, definitions. Basically removing from Division 80 all of the definitions. We will have a directive that basically sends the applicants to Division 20 for that, and we'll use one standard set of definitions. Part of the reason, or main reason for that, is in our current rules we use some definitions that are the same word used for the same program, but we actually have two different definitions. And that actually happens a couple different times. Or a definition is not used in division, or is used in both divisions, but only defined in one division. And so there's several of those instances. So by going to one single division will help us be able to manage and maintain and have that consistent dictionary. So going through this next step is where we're getting into more of the actual process. And so I'll be jumping through and kind of showing this diagram again as we walk through this with each section. So you kind of see where we're going. We're basically going to start from the top and more or less work our way down through this process. And that's kind of what I mentioned earlier, is trying to have this as a lineal process and having our rules support that lineal process. That's also how they're kind of organized, so that it logically flows from getting a complaint through final order appeals, those kinds of things. So the first section in here is complaints and investigations. It's obviously at the top. In this section, we have quite a bit of it in both sets of rules that I built on. But basically, it really comes down to, we can initiate an enforcement action based on an investigation based on information we receive or what we see firsthand. We can get complaints received from the public. One thing that we did add from Department of State Lands is a clarification that complaints can be anonymous. There are still public records laws and Freedom of Information Act that relate to that, but by having this, at least we can provide that that little bit of cover initially, and again, following some existing language that other agencies are using. The other part that's in here is related to kind of our on-site investigations. I do have in blue text with a comment, I did have a section that relates to what the department can do on accessing on the ocean shore and on property. We've been told by the Department of Justice that they're going to probably refine that that language to reflect current case law. But for now, we're going to keep that language in because it seems pretty consistent with what's out there. But they were going to look at that. So just helping clarify what our staff can do. Again, some of that comes from statute as a base, but then having the rules clarified a little bit more as it actually deals with how we can perform our investigations. And then a new piece or expanded piece based on existing is these investigatory hearings. The way the rule was written previously made it sound like it was more of an appeal hearing, and a part of it's the language we were using, hearing for everything. But basically, it is a process in which, in certain cases where we might need to, invite the public to have a discussion, find out what the impacts are, find out what more background is, that we can actually have these investigatory hearings. And so it might be multiple agencies, it might be the public. It's pretty open-ended, but just clarifying that we have the ability to do that. And so that takes us through kind of all of these elements of our investigation. And so our next section is, what can we do then, right? And so again, clarifying our statutory directive of being able to have any action we want is between civil, criminal, and administrative actions. So that is something that is clear within our statute. So, but what does that mean, right? And so taking kind of what we're framing up as remedies now is, what is it that we can do individually or cumulatively to basically address the violation? And that is these actions are going to depend on the severity of the violation, the cooperation of the landowner, the level of impacts, those kinds of things. But really what within the remedy sections I've tried to do is, with new information, is really try to list kind of the pick list of the most common things that we will look at. And part of the reason for that is our current rule is silent to those for alteration activities, and we have through other rules within a department and through other statutes within a department, we do have the ability to pursue things like, you can take an example, writing a citation. Well, nothing in our current Division 20 references back to, hey, a citation is something we can do. And so it becomes one of these question marks of, well, we don't have a rule that really says we can, but we have another rule that seems to imply we can. Does that actually apply to alterations in it? So trying to get rid of that kind of second guessing and make it very clear that, yes, these are some of the options, and really trying to spell that out up front here as effectively like a table of contents to of these are the different things we can do, and referencing some of the other portions of other rules that the department has, so that we can connect with those within our enforcement actions. And so as you look through this list, really kind of these couple first bullets here are setting up to, the different types of overarching things we can do. We can have them comply, restore the site, pay a penalty, pursue some sort of mitigation or compensation, and also having it to where they could forfeit their right to apply for a new alteration permit or perform an alteration. And so being able to, and that came out of the forfeiture pieces were directly taken from some language at Department of State Lands. And realistically, that'll be 4 times where either they're really egregious violations, or I'll say egregious violators, or where we've had multiple violations, those type of things. It's one of those elements that allows us to kind of step up our action. And because we've had times where applicants will have an enforcement action, and then have a permit, enforcement action, and want to get another permit subsequent to that, and it just starts kind of snowballing. And so being able to kind of frame that up right off the bat. And then the other remedies is going through how we do that, right? And so that's where I was talking about just all of these different administrative actions we have. And in this list, some of them are self-explanatory. So there's just one statement in this list. Others also have a supplemental section later on. So like the notice of violation, order for corrective action, some of those have a dedicated section later on that's referenced, but others are pretty simple. So like the citations within this, pretty much saying, hey, we can issue a citation pursuant to this ORS and and do that. And so again, it doesn't need further explanation. So again, it serves both as a table of contents, but also it's kind of its own list. And so this list is pretty much it's based on existing options that we do use, have used, but most of this is not spelled out in rule. So it is all pretty much new rule, but it is based on kind of elements that are out there. The one part that is not in the current rule is related to the self-help, and it's been modeled after some other programs, but basically it's something the agency already does, which is if we go out there and something is a public, safety hazard, our staff may go and remove it from the ocean shore. This has helped clarify that, especially if there's a significant cost incurred by the department to do that, that we can actually go back and have that cost recovery as part of our enforcement action. Charlie, I saw you had your hand up there for a second before I jump on past the remedies.
No, you just answered it. I was going to ask about the self-help, so you just answered that. Thank you.
And Cameron?
Yeah, hi. I did have a couple of questions about this section when I went over the materials this morning. I found the section on OPRD self-help to be really confusing until I realized that it was the term that was confusing. It's not, I think that's not a good term, OPRD self-help. It makes it sound like the agency is helping itself to whatever it damn well wants to see or do. And self-help has, as a term, has a lot of, what do I want to say, resonance with, mental health and things like that. And which is totally not what we're talking about. I think it would be much better if the agency came up with a better term that better carries the issue that you're trying to do, which is you're saying if you go to the shore and you see a situation and you either can't find or don't have the time to find the proper channels to get something to be done, you can just go and do it. But there must be a better term. It was really confusing using that term.
Okay, appreciate that.
And the other thing, I think it's in this section, I have to go back to the documents, where you can exclude people from the activity for 6 months or 1 year or 5 years.
We'll get to that in just a little bit later.
Okay, I had a real question about that section.
Okay. No, absolutely. Well, it's mentioned this, but it references down to the section 7. So we'll get to that here in just a little bit, but we'll make sure we stop there. And then the next kind of section within that is the cease and desist orders, pretty much based on our current language. It's really set up to kind of frame down, we'll call it emergency enforcement actions is probably the best way to put it, where they've done something that is either going to cause more harm, they're going to keep working. Somehow we need to step in and say, you need to stop right now. We pretty much, it's either clearly a violation or it appears that it's either going to be or is a violation, but we need you to stop so we can have the time to take care of this. It does put a cease and desist, or does put them on an appeal process. However, it is not the order is not stayed during that appeal, so they would be shut down while they're going through the appeal. So again, it's to get kind of the attention of the landowner, get things shut down, and allow us to take that next step of figuring things out. And if we go out and ultimately find that it truly isn't a violation, then we can rescind that, or if it is a violation, then we start going down one of the other tracks that's there for resolution. Charlie?
Yeah, I haven't had time to really dig into some of the cease and desist. I guess one of the things I was curious about though is like is there a is there any sort of discrimination or difference in the type of property owner? Um, and I'm thinking government to government. In particular, I'm thinking like federal government to state government, and how the authorities of and these actions do or don't apply. Does that make sense? Is there any difference in how
So
how
you're
the type
thinking
of property or the property owner, like, does this, I guess I'm just kind of thinking about your authority over federal actions on federal lands that obviously cross over or within beaches and federal land has always been a little confusing. And enforcement and jurisdiction, particularly I've seen this pop up a few times around snowy plover restoration stuff, and then also, the Cape Perpetua area. And so I'm kind of curious in the back of my mind for a number of reasons about how the authorities may change based on the relationship with us and a federal entity.
Yeah, and I guess my answer for today on that is that's a really deep question. It is something that we have raised with Department of Justice. We have not gotten a clear answer. It is something, or at least clear answer yet. It is something that we're still kind of having those discussions. It probably is not going to be something that we resolve during this rulemaking, but is on our staff radar for trying to get it clarified for potentially for subsequent rulemaking, just because it is a big question, but in reality, it's a very small amount of, I'll say, issues out there overall. And so kind of tackling one thing at a time, I guess, is the way I would phrase that, because there are different opinions on kind of how that lays in, and it is a federal sovereignty versus state ownership versus regulatory framework, and kind of where does that go, and that needs a whole different legal review than probably we're going to be able to do as part of this rulemaking.
Oh, I'm not
But I
suggesting
think
we
it's a good
try and
question.
fix the CZMA trick here in our rulemaking process by any
Yeah.
means. I just think I'm just putting a pin, is this where
Yeah.
that will be? Because I suspect we'll be doing a lot of that in the next year or two.
Yeah, I think where I would go, at least with the cease and desist orders, if we have authority and jurisdiction over an entity, then we could utilize this. Where we would go during a situation, let's just hypothetically throw, we have a federal violation on the ocean shore and we think we need to do a cease and desist, we would probably be number one talking with our legal counsel and having that discussion to figure out, based on that location, what's going on, how might it frame in, and do we actually have the legal authority to pursue a cease and desist or an enforcement action for that matter? Or is this one where we just need to reach out and basically say, hey, we've got a federal consistency issue, or some other element that is maybe more appropriate given, it's like you said, more of a CZMA. So there's kind of those two questions that come into play, and so yeah, I don't think our rule will address that, but it's something that we would address procedurally as we move forward with any sort of action. Does that answer your question, Charlie?
Yeah, I mean, I wasn't really looking for an answer. I was sort of posing the question of like where this lies. I guess at the end of the day, where the enforceable policies lie of the state in this arena. That's another discussion.
Well, and it's not only just enforceable policies, because that's more of the CZMA, it's also the jurisdictional aspect. And I'll just use experience I had with, because we haven't had one yet here since I've been here, but like when I was with Department of State Lands, we would have railroads, hydro projects, things like, and there's a whole different set of rules, federal rules that relate to those and how they pertain to the programs, and how the state law then actually dovetails with those from a jurisdictional standpoint. And so that's where those federal laws need to be peeled back, because if it's a railway on the ocean shore versus a jetty versus a habitat project, there's likely three completely different sets of federal laws that would have to be looked at to figure out whether or not we have our authority would extend to the federal within that
Yeah,
federal
it
realm.
seems like constantly I'm running into the fact that in most joint application processes of the state, parks is last, or maybe not even privy to that process. And I can think of cable landings and other things in that sense. And so that's why
Absolutely.
I'm asking these questions too.
Yeah, no, I appreciate it. And let's see, I think, hold on, I'm just looking at something here real quick. Okay, so moving down the process. So one thing, so we did not spell out a section here with this consent order. Really, the consent order is just that it's a cooperative agreement that we come up with the landowner. Didn't build really any rules by that other than just, hey, we can resolve it cooperatively up in the main section. But the notice of violation and the proposed order sections we did build out. In the rule we use the term order for corrective action. Why the chart has it as proposed orders, because there's in any of our orders it's proposed first and then it's final once it's either gone past the appeal process or the appeal timeline has ended. So there, as we look at this, the notice of violation, as I mentioned, really is this piece that's used to establish factual matters. And so it can be used independently as a way for us just to document to a responsible party that, hey, we caught you, here's what we found you doing, there was a violation. Basically you're on notice, kind of think probation, I guess would call it, but you're on notice that if you do something in the future, it will affect you. And that could include getting a civil penalty in the future if you continue to violate. But really it's the who, what, when, where, why, and how, right? That's what this notice of violation is getting at. And then that notice of violation is the foundational element of any other order we have. So the consent order would include a notice violation. There may be less facts stipulated, partly because we're coming to a mutual agreement with the landowner. And really by them signing, they're saying, yeah, I agree that I did something wrong, and here's what I'm going to do to resolve that. On the other end of it is the proposed order, which really is this is based on our existing rules, just with some clarifications of like the name in that. But basically the proposed order is going to dictate what we are telling them to do, and having the notice of violation included in that effectively is what gives us our legal case that if they appeal, those are the factual elements they would be appealing if they were to contest that a violation had actually occurred. And so that's part of why that notice of violation is something, the content of it is included into all of those as that stipulated facts. Hopefully that makes sense on how those fit together. One of the things we can do is, and a frequent use would be if we would be conditionally waiving a civil penalty. So we can do this both in a consent order where the landowner agrees like, okay, I'm not going to pay the civil penalty, but I agree that I'm not going to violate, and otherwise I get the civil penalty. We can also do that in a proposed order where we put in the civil penalty calculation. We basically say, we're at this point in time, we're waiving it for these reasons, but if you do something in the future, here's the civil penalty can be active or activated, I guess I should say. So that is one other option. So revoking and suspending is really it's a specific type of enforcement action. It is called out separately, but really the way we would be handling it under the proposal that I have is that they would be handled through a proposed order or potentially a consent order, where somebody has done something wrong. We're basically saying the permit is not viable. The reason for kind of this, for the revocation in particular, is that it's a permanent closure of that permit and it is subject to appeal, well, really, we're only going to be doing a revocation if there is some sort of violation. And so using this existing process is that makes the most sense because we're really using it as an enforcement tool to shut that permit down and basically say, we are pulling back our authorization. So within this revoking and suspension rules, I did use it to kind of spell out more on when the agency would look at doing a suspension or a revocation, and then clarifying what the differences are between a suspension and a revocation. And the suspension really is a temporary stop on the permit for them to figure out how to correct the issues. And so that is kind of built in under the permit conditions. It's, hey, we need to stop. We need to figure out what's going on and figure out how you can bring the project back into compliance. If that then lasts longer or they're going into a point where they're not going to fix anything, then that's where we would pursue the revocation. So hopefully that makes sense. And currently the rule is very generic. It just says we may suspend or revoke or not renew. And it's very much open-ended. So we now have much clearer and objective standards for doing that. Go ahead, Cameron.
Yeah, okay. This is where my question was. I understand the temporary prohibition or alteration as opposed to absolute revocation. And I understand the difference and the effort to try to work through the situation in a temporary prohibition situation. But 5 years, that seems really long. I mean, I think the period for prohibition, a temporary prohibition, should be really limited, much less than 5 years.
Okay, so let me jump back. So I was talking about the suspension, and the suspension would be of the permit, and the suspension of the permit would be up to, I think it says 90 days, and then over that it would be considered a revocation. So that is for the suspension, but you're absolutely right. The temporary prohibition is the next section that I was getting to. And so let me jump down to that. Unless Rihanna, did you have something on the suspension and the revocation first, and then we'll go to the temporary prohibition?
No, but it's on temporary. I can wait.
Okay. So temporary prohibition is a new thing. So it kind of, I want to give this group kind of a little bit of background on where we came from. So our department has an exclusion program where we can basically effectively or give somebody an order that says you can't be on a state recreation area or a state park for a certain amount of time. The original proposal by staff was to dovetail with that process. After talking with our internal coordinator on that really wouldn't work for several reasons. But basically what I came up with kind of after our internal discussions was this temporary prohibition. And again, it would go through the proposed order process, but really it's coming down to this is something where if we need to effectively put a pause on somebody working on the ocean shore, what this was trying to do was to set up under these scenarios, here's where we would be prohibiting you from operating on the ocean shore. So if it's a frequent but maybe small violations, then we could potentially look at something short term. Whereas if it's a frequent large term, you're kind of getting to this, we've tried every other measure, then we would document that history and basically say, look, we're pretty much telling you can't do alterations on the ocean shore for the next up to basically 5 years. And in extreme cases, I think it says over 5 years, but that was the context behind this, was having a way that we could objectively kind of apply some of these pauses. I will say that's part of what I was hoping we would talk about on this one, because it is a concept. It could be thinned down, it could be tweaked, but the concept was really to try to have an objective standard that when we get to these points as a department, when we're having, in particular, frequent applicants who are applying and violating in a recurring kind of I'll say it's a cyclical problem, right? It's I get a permit, I do what I wanted, not what you told me to I could do, get in a violation. Well, now I want to do something again, and now I'm in violation of that. And we now have multiple violations sitting that are starting to stack up, and it's not fair to the public, it's not fair to the ocean shore, and it's not fair to our staff. And it's just become we need a way to hit pause on some of these. They are very infrequent. So this isn't necessarily a critical rule, but looking at it from one of those tools in the toolbox to be able to say, hey, time out. We've hit a point where, we're not going to consider you on the ocean shore right now, as part of an applicant. So Rhiannon, go ahead, and then we'll jump back to Cameron.
Yeah, just two quick things. One, I do like the idea of the temporary prohibition. One, I don't know if these titles are like official in the rules or just for the slides, but I would suggest putting temporary prohibition of future alteration just to kind of help differentiate from the first one for the revoking, just because I know that like within the rest of the text it does differentiate, but that might help just when people may not read all the way through and get a little confused. The second thing, I like the idea of this though, because I think it can also help with cases where the property owners maybe are not as concerned with the civil penalty fees, even if they are increasing over time and moving forward. That sometimes that's just not really an issue for some of the oceanfront property owners. So this may be an incentive then to not continue to violate on the ocean shore. Thanks.
And I would say it's not just landowners too, it's contractors. We've got some contractors like, well, we'll just pass the fee on to the landowner and we'll just do what we want. So, Cameron, hopefully that explained a little bit more for you, and I'd love to hear what your thoughts are on this.
Yeah, that does explain it a little more. And I think I didn't mean my earlier comments to indicate that I don't think that temporary prohibition is a good idea. I do think it's a good idea. And I think it's valuable for OPRD to have a set of standards that will actually do something against frequent violators. I've seen contractors who do exactly what you say. They get a permit and they just go off and do whatever. And they figure they've got the bulldozer and you don't got the bulldozer, and that's about where the conversation ends. And that's not good. We can't do things like that on the ocean shore. My concern is that this is a short-term, not slap on the wrist, but punch to the midriff. And I don't think it should be a long, dragged out process. So to extend it to 5 years or 5+ years, I think is really extraordinarily too generous and too long for an interim procedure. It should be, I would say, no more than a year. And if it continues after a year, then revocation should occur.
Well, and I guess let's make sure. So revocation and suspension relate to an actual authorization. What this temporary prohibition would be more to a responsible party, right? So it's
not the temporary prohibition does not relate to a permit. It relates to just actions.
Basically, yeah. So the suspension and revocation would relate to an authorization that we had given, and effectively the suspension would be, hey, we came out, we did an inspection, you're not in compliance. You don't do any more work. Your permit's suspended until we figure out how you can bring this back into compliance. And if you figure that out, great. Versus if you're out there and again, you're not working with us, you're just doing everything, completely contrary to the permit, then we might revoke that, right? This is then the temporary prohibition of, I like your idea, Rhiannon, of the future alterations is really more of looking at a tool for contractors or landowners that are problematic. And as you said, and it kind of that we as an agency have tried to work with you in the past, and really it's not in the public's, I'll say in the public's interest for us to work with you to do something in the future because you just keep doing things wrong. And so that's what this is trying to get at, is it becomes effectively a probation, call it an ocean shore alteration probation, right? Of you're not able to apply, work. If you're a contractor, we're not going to allow you to be on the, get a drive on beach permit to do the construction activities. We're not, and a landowner can still get a permit, but you might not be able to be the contractor under that permit, right? So those are the kinds of things. Or on the other side, contractor might want to do something for a landowner, but the landowner is prohibited. So again, it's that trying to connect those dots of those under who's the responsible party, and it goes back to that definition, which is the landowner or kind of their agent, that is, whoever is doing the alteration. And so trying to tie back to that. So that hopefully that clarifies those, because this is more about the people. And that was part of why we added this, is because our current rules didn't necessarily have anything about the people. They have it about the permits, they have it about the civil penalties, and those are great tools, but sometimes it just needs to be a pause. And I would say these are, again, that most things are going to be handled through the consent orders and smaller things, and that's where we want them to be handled. But part of it, we kind of need these bigger sticks to be like, we've tried every other avenue to work with you. We now have enough behind our case to say we're going to move this forward and say you need to be off the beach for a while, and then we kind of call it a cool down period, and then we can come back and have in a couple of years, let's have the discussion, and hopefully we can then figure out a way to move forward amicably.
Yeah, I guess I think that all the more when this section is about essentially creating a leash for bad actors rather than people who are going over their permits, that the probation period or the temporary prohibition of future alteration, I like Rhiannon's idea too, should not be an extended thing like 5 years. It should be, I think the maximum should be a year. That's actually a fairly long time. It's a full seasonal cycle before something more permanent is put into place, whether to allow a permit or to disallow a permit. I don't think that this kind of intense stop situation should be going on and on for 5 years. And then my related question is, how does this mesh with or not with the cease and desist order?
So the cease and desist order, as I said, is more of a quick action, right? It's, hey, we need you to stop because there's an immediate threat of violation or harm to the ocean shore, and we need to get things going. It does not resolve the violation. And so it really is it's a legal way for us to shut them down. And again, in 3 years, I don't think we've used it once. It's not a tool we use a lot, because most of them are, if they either happened or they're not really kind of this, I'll call it immediate threat for a big problem, or if they continue to work a little bit, usually we're able to get their attention off, and kind of get things moving forward with lesser means. And that's how we would do this. But the cease and desist, typically it is for those, like I said, I hate to use the term emergency, but it's kind of that thing where, hey, we got it. And it's like, wow, we got to stop this work right now. And that's what that's for.
So this temporary prohibition would not be a stop this right now situation?
No, this would be, so I think this would go through the proposed order. So again, kind of that resolution stage of it, and kind of getting to your point about like the 5 years. So the way this is set up is kind of on a sequential, where we would start at a lower level, 30, 60, 90 days, depending on kind of that violation status. And if somebody continued then to, beyond, we give them that, say, like, let's give them a 60-day to begin with, right? And then they go out and they come back, they're like, hey, we'd like to try this again. They violate again. Well, maybe then it becomes 180 days, right? And then after that, it's like, okay, let's try this again. Well, you're violating. That's where we'd be then looking at, a year or 5 years, start. So it would be that sequential. We wouldn't jump to a 5 year, prohibition unless it was just, I'll say, the worst actor being the worst person doing the worst things to the ocean shores. But pretty much even in that case, we would start lower. So I think that just to kind of, that's how this is supposed to be framed. And if it's not reading that way, I'd love to have that feedback, because it was, and maybe that's where we have fewer. One of the options when I was looking at it as I was kind of revising it was having actually fewer categories. So it's like, hey, you have kind of a tier 1, 2, and 3, where the first one is 90 days, the second one's a year, the third one's 5 years, and that way it's kind of this, hey, we're going to let you try these things, and if you just aren't getting the point, then you're just not getting the point, right? So hopefully that helps answer your question on that, Cameron. John, I saw you had your hand up patiently.
Yeah, just kind of one thought or question actually. So if you apply this to a property owner versus a contractor or other professional, if the property owner actually has an issue, I mean, these things happen. You know, an event occurs, and all of a sudden they actually do need they need a permit for something. This prohibits them from. I mean, this isn't going to prohibit them from applying for an emergency shoreline protective structure permit, is it? If they need one?
I mean, that would be, I think that the way it's written currently, that would be the read of that this would be a prohibition of applying for or getting. And again, part of that is, and I'm going to say this is kind of that trust factor, right? Of like, hey, before this gets applied to you, you've demonstrated ocean shore. I mean, that comes down to, and that was the intent, is again, this is probably something we would use very infrequently. But it's one of those things where, and I should say the longer ones in particular, the 30, 60, we might roll those in, more frequently. But in that case, by the time something new is happening, it's realistically that we'd be looking at them being off. But the longer term, it would be, you're absolutely right. It's one of those things of where it's like, now you've been out there, you've messed up 10 times over the last 5 years. We need to do something. So yes, it would, under the way it's framed, it could prohibit a landowner from applying. If there was.
Yeah, no, that makes sense. I guess I would make a recommendation that the agency itself has the discretion to lift the prohibition. And it may be in there. I'm not seeing it. But if you have the ability to just say, yeah, actually because if something happens, first of all, a ranger or somebody's going to be able to observe it. It's going to be some kind of weather event. You're going to see that, okay, actually they're going to need an emergency riprap permit now. And because your agency does understand when these things are necessary, internally, the agency can say, okay, you know what, actually we're going to lift your prohibition for X number of days. We're going to allow you to apply for an emergency riprap permit because you're clearly going to need one. And then terms and conditions apply. I mean, that's just a suggestion, but that way you have the discretion to lift your own prohibition when you see fit.
And I think that is, that is a good. There's always good to have those kind of, I'll call them a pressure relief valve, because you're absolutely right. There could be times where, an event happens that none of us expect, and it's an all hands on deck, and it's like, yeah, we need to do that. So I like that idea, John. I'll look at how that might built in.
Okay. All right. I think I had one other question. I guess on the contractors, I mean, that doesn't necessarily matter, but actually, no, it doesn't matter. It's any party. Typically, you want to have a remedy process, and maybe this reverts back to your internal process. If you make a decision on something, I assume these prohibitions are basically the agency making a decision. So as a decision of the agency, is it appealable just like any other, would it be appealable like any other agency decision, I guess?
Sorry, you cut out. I don't know if it was on my end or your end, but you're asking about whether these temporary prohibitions would be appealable, and if the.
Yes.
Yeah. And the answer would be yes, because they would be done through a proposed order. So that whole process is, so basically, like I said, it's kind of as looking at as a resolution. I mean, during this, it could be one of those where there's a civil penalty, there's a restoration plan, and we basically say, yeah. And once that's done, you're off, we're basically saying, you're off the beach because of these reasons. We're also saying you're off the beach once this is restored. So that could all go in, and then again, that's our package that we put forward. Their right to appeal is then exercised, and go from there. And as I said too, there could be, we're dealing with a situation right now where having something like this could actually be a more valid resolution than a civil penalty, where we could be doing a civil penalty, but under a consent agreement, we might be able to meet with them and say, or through a negotiation, say, well, instead of a civil penalty, would you agree to being prohibited for 90 days, 180 days, whatever, whatever seems appropriate based on that. And this is a contractor, and they might say, yeah, we'd be willing to do that. We just don't want to pay the civil penalty. And again, that allows that. So that would be where it wouldn't be appealable, but it would allow us a negotiating tool as well.
And just my last thought: if you are talking about a contractor that has a pattern of actions that violate ocean shore policies, and basically they are basically if they're a bad actor, all of a sudden 5 years doesn't seem like that long. Because if you have a contractor or a professional that's doing something consistently that's serious enough that they really are creating a lot of problems, I don't know that I actually know of anything like that, but it's possible that can happen. Prohibiting them from applying to the agency for a permit for a period of 5 years, that doesn't sound like a bad idea. That might be one of the few instances I can see a 5-year time range making sense. But even then, I don't know. It's case by case. Anyway, that was kind of my last thought on that. So.
Okay, Rhiannon?
Yeah, I think one way to further distinguish between revoking and then the temporary prohibition would be just to clarify that it's revoking existing or suspending existing permits, and then for the temporary one, future. And I think just having those keywords in there would be helpful. And so for the temporary one, specifying durations of prohibition for future alterations. And I think it might be helpful to add language so that it is clear that it's for property owners applying or for the contractors, because I don't know how it is written right now, but in this it doesn't specify that it's for both. So I think that would be helpful. And just a thought that probably wouldn't apply to this right now, but what John was talking about, for contractors who have multiple violations, it just made me think of when people have multiple driving violations and they have to go back to driving school, right? So maybe having some sort of training in the future for people who have multiple violations of hey, you have to go through this training process to maybe apply to have your prohibition released or something like that might be helpful. We could come up with some kind of training program.
It's an interesting idea. It has been floated, and I guess I'm just going to ask the group, since we have everybody here. One of the things would not be part of this rulemaking, but it could be part of a subsequent rulemaking, was the concept of when you look at the standards to protect the public, deal with public safety measures, protecting the resources, especially for construction activities, staging activities. One of the concepts was to actually develop a training program, and basically, I'll call it, for lack of a better term, a certification or licensing of, you have to be a contractor that's gone through this training in order to operate on the ocean shore. Again, don't know what that would look like exactly and what frequency. That would all have to go through an advisory committee and have that discussion. But I'm just curious, since you brought it up, Rhiannon, is from this group, would that be something that we should explore as a subsequent rulemaking? And I just, again, just love to kind of get that as a sense. Diana, you had your hand up.
Yeah, I'm following up on what John was suggesting, that if there is an emergency that you would remove the prohibition for a homeowner. And I understand his compassion and I share that. But I also think that the person who is in this penalty box is the last person you want to be working with in an emergency. And so I was kind of thinking exactly along the lines of what you've just brought up. If there was a way if you feel that you need to be able to remove the prohibition in an emergency, if there was a way to have some pretty clear parameters, if this wouldn't be a time when you would require a project manager and a contractor of your choice, or, as you're saying, have a group of contractors that have been through specific training. And I think the training is a great idea and really needed. So if you were inclined to remove your temporary prohibition, if in an emergency, I would hope that you would have really clear processes in place so that it could be done as well as possible. That's all. Thanks.
Let's see, John, go ahead.
I agree with Diana on her follow-up comments on the lifting the prohibition, and also, yes, I agree that training would be an excellent component to this program. And I have no idea what model you want to use. I know there's an erosion control training program that ODOT uses for their contractors relative to their infrastructure that's pretty effective in keeping their infrastructure safe from other adjacent projects. And something along those lines. Obviously, you're going to have to lean more into coastal habitat protection and things like that. But yeah, I think a training program would be excellent, and a certification or licensing program might be warranted, and probably would be excellent as well. So. Yeah.
Charlie?
Oh, I'll just third all of that. Training program, great. The more specified, certified that is, the better. I think there's a number of people on this call. One hand just went up, who can speak a lot about some work in this area. And so I'll leave it that to Felicia and others. I think that there's some good infrastructure in place, though, for us to build off of that idea. So I totally support it. And I do agree. I think there's some concerns about lifting prohibition, particularly in certain emotional states and times, and how that happens. I would hope if that was going to be considered, I agree with Diana. I would want like really, really tight clarity on how that happens. I'm quite pleased with that as it stands, actually.
Alicia?
Yeah, I just wanted to say, yeah, I agree with the idea of the training program. And I know, like, the coastal training program through the different, like, National Estuary Research Reserve could be a venue, but also I tried to do a quick search, but through Sea Grant as well, it seems like Florida Sea Grant has regional living shoreline courses, which is a 2-day course covering basics of shoreline stabilization, permitting, design, construction, and maintenance. So there are probably, some existing training out there that, we could explore. So yeah, just wanted to add to that.
Great. Yeah, definitely more to come if we start looking at some sort of training program. So thank you. Anybody, I'll say, since we kind of heard a lot of the support, anybody opposed to considering some sort of future training program? Just Diana, did you have another comment?
Yeah, and I would love to see a state-sponsored training for geotechs and coastal engineers as well, so that everyone is using the same terminology and the same processes. I called out in the Google Doc a few places where, it'll say things like erosion rates, and I would like there to be clear guidance on how erosion rates are determined, and for there to be, some standardization. So that's one thing. And then I also just wanted to mention that Washington Shoreline Planners Group has an online 6-part series that is on shoreline management, and one starting on the 13th, and I know there's still some openings, but so that might be something that someone from your group might want to. The one that's starting is self-paced, and it's, I don't know, through like a couple months or something, but that might be something that somebody on your team might want to take a look at and see how Oregon would like to do something similar.
Okay. All right. Well, in the interest of time, I'm going to jump ahead. Thanks for the feedback. Would definitely like to see your thoughts on the Google Doc. And if you, now that we've explained that a little bit more and you've had a chance to look at it, please reach out, because like I said, that is a new concept. I don't expect it to be perfect. Framed it off of something that existed, but yeah, I definitely would love your feedback. Civil penalties. This section is, the way I will frame it is, it's a revamp of a similar concept to what we have currently have in the rule, but it is a much more defensible approach. I think I've explained my background too. I worked on updating the civil penalties at Department of State Lands when I was there, and had similar discussions of how do you make these defensible. And our current rules, it's really tough, because we have things in our calculation like the number of previous violations. Well, you could have had 5 really minor permit condition violations, or one major, catastrophic violation, and they are effectively counted the same. And so it penalizes somebody that may have done a lot of little small things, but have been trying overall, versus somebody who's just, we got caught one time for doing blatant stuff. So again, you really got to go back to more of, again, those objective standards. So this is, to me, it's more of, it's a lot more defensible on that. The state limit on civil penalties is $10,000 per day. That stays the same. We are required to provide a notice for any civil penalty, but we would do that through the order of corrective action, through that process. And then or consent order or the notice violation. The notice violation might be one of those where it's like, hey, we caught you. Here's what the civil penalty would be if you were, if you were caught continuing to violate, that kind of thing. But it's more of a FYI. And then the proposed order is where we would actually issue or either waive a civil penalty. But the calculation itself, couple of key things. What I did is I based the new one off of the updated Department of State Lands version, so it became more objective. With that, using their base fee, ours was 500. That's what DSL's used to be. Theirs is now 1,000. Part of that is at 500 for a lot of the smaller violations. It's not even, it doesn't come to a civil penalty that's even worth our time to kind of issue. And it doesn't recoup our costs, especially legal costs, if we get any sort of contested case or anything of that nature. And so it's just, again, and it hasn't changed. It's been $500 since at least 99. So that was increased. And then the levels and the criteria have been adjusted within ours. It's a very similar calculation, where the penalty is based on a base fine plus their knowledge, the cooperation, and then the impact. Like I said, our current one also has a violation calculator in there too. And then we also added in places where if they fail to pay, that there's the ability for the state to go towards collections or liens. And then we also can reduce or waive the fees. This is something that's currently in rule if they're cooperative or if they have financial hardship. And so there's some stipulation by that. So what I wanted to do, and I provided this table to all of you, is, without going through each of the rules, I'd really like you guys to make sure you look at those, each of the factors within that formula, and kind of see what you see in there. Because the way these change from this top one is our current civil penalty calculation. And so it's the penalty is the base fee times the cooperation times the number of violations, their prior knowledge, and their impact, where now it's the base cooperation, knowledge, and impact. So again, it's effectively just getting rid of the number of violations. The multipliers that are used have also changed a little bit, where like cooperation, we had 1, 2, and 3. We've now gone to 1, 3, and 5, because trying to figure out that 1 through 3 is kind of what you nuance it, where what we're looking at is basically if you're cooperative, you're 1. If you're being hostile and belligerent and really just kind of a bad actor, you're going to get a 5 under the new one, right? So it's that we need something to help a little bit. I'll call it the carrot and stick, right? We really want to try to persuade people to work with us and voluntarily resolve issues. But if they're at that point where they're being hostile to staff or, some of that type of stuff, then we may be looking at those higher numbers. So really what I did is I ran through kind of this little middle part here is a very simplistic review of kind of what the scenarios were, and basing it on the new base fee, and then again the numbers that would relate to those factors, just to kind of compare what things would look like. And if you notice on our existing, under all these kind of initial scenarios, they're all $3,000 or less. And it really is because of the limits to the calculation. And so under the new one, where you taking like this one here, where you see there's a much different $12,000 versus $3,000. Yeah, it might be a first violation, but they're really uncooperative. They did know about the program, and but yet it's a relatively simple restoration. But it's that whole, again, the uncooperative nature and that prior knowledge. And what this would be, given kind of why it was a 4, is they've gotten permits, they've had, they really knew what the program was, but then they just went out and did something, right? And so it's being able to kind of pull some of those things away from incentivizing a violation. But yet when you have somebody that is, maybe doesn't have as much knowledge about the program, kind of a similar situation here, it's a more reasonable number. The one piece that I did add, based on Department of State lands, I'm not sure that's 100% necessary after kind of running these calculations, is that if you're basically uncooperative and you had knowledge of the program, that it doubles the civil penalty. But as you notice on all these that have the red dot, they all exceed the $10,000 per day, so they would be maxed out at 10,000. So that is something I want to make sure that I'm clearly showing, is this is just the simple calculation, but any of these that are over 10,000 would automatically stop at 10,000. So hopefully that kind of helps frame up that calculation a little bit better. If you guys have any questions about any of the factors that are put into that equation, I'd be happy to talk with you through them if you have any questions. Diana, it looks like you do.
Hey, so you say no knowledge. Can you tell me how it is that the person would have no knowledge, or give me an example of when that would apply?
Yeah, so basically, when we're looking at this, it's going to have to be what we can prove. And so if you look at the rule, the way it reads right now is a value of 1 is applied if the alleged responsible party was unaware of the ocean shore alteration laws at the time of the alleged violation. So that would be where, if I've never had any contact with them, we have no record of any contact with them, we're going to put a value of 1, right? Because we don't know that they were aware of it. We have no documentation. Where if we've had a phone call, that might be a level of 2. But if you look at 4, was you had prior documentable knowledge of the ocean shore alteration law. So we've issued them a permit. We've had email exchanges with them that give them substantive, information on what they should or shouldn't do, and then they just go out and do it anyways, right? Or if they need a permit to do something, and then they go do it, right? So that's part of where that was built in, is having that. And I said before, it's kind of that objective standard, right? It's something that's we can defend. And so they're going to default at the lowest level, and then we're going to have to prove that they meet that higher level.
Thank you. I think the 500 is really low. And I noticed in the conversations at the last RAC and today that you seem really uncomfortable and as though you need to explain these higher numbers. And I really don't think you do. I think that this is, very reasonable, even at the 10,000 a day. It seems laughable that somebody's buying on the ocean front and doesn't know that there would be some rules around that. And, in the original document that you gave us from the work group in 94, I think it was, there was discussion about some pre-purchase documentation and, maybe that's something that you guys want to do where you're following purchases on the ocean shore and when somebody does purchase, you send them out their packet and then they can't say, gosh, I didn't know, of course they can say, oh, I didn't read it, I didn't get it or whatever, but $500, that doesn't even seem like it's going to cover your guys' time to give the violation and to have the conversation. So I would encourage you to increase these numbers.
Okay, Felicia?
Yeah, I would say no, so far I agree with, the numbers and I like the scoring and I like how you, for each factor and how how the scoring is explained in the document. I appreciate that. Something I was just curious to ask some clarifications was related to why are you removing the number of violations for this, proposed version, just out of curiosity.
Yeah, so again, first I'm basing the model on kind of the DSL's updated version, but the main one being we've had a couple of recent civil penalty calculations that we've gone through and trying to document the number of violations has been very problematic because how do you define that? Do you define that as you got a notice of complaint and then you just kind of resolved it? Maybe we didn't follow up with further action. Is it, if you only got A or B, it becomes one of those things of like, where do you count that? And then, as I said earlier, if you've gone through and you had, let's just say you've been a frequent permittee contractor, but you've had 5 different permits, and each one of those, you had a violation that got documented, and you got a, some sort of corrective notice, and you fixed it. But that was technically a violation, and you've got 5 of those. So now all of a sudden you're counted as having 5 violations versus somebody who basically said, I don't care about the regulations. I'm going to go build the biggest, baddest thing I want, but they only did it one time. And so it really, to me, it just didn't make sense because you were penalizing potentially for the wrong factor. And number of violations doesn't necessarily mean severity or the issues that go along with it. And so trying to take that back to more of these more defensible pieces, because again, on this one, we ended up with going with a low factor, even though we've had tons of interactions with this individual that we could document, we couldn't document all of those as actual official violations. And that made it really challenging. We're under the new scenario with the knowledge being the key part of that and building in that violations, we easily could have had it to a higher knowledge number and defended that. And so that's really what it comes back to, is being able to have that defensible and objective number, and the number of violations just doesn't get to that. It just creates a level of complexity that I don't think is necessary and doesn't really get to where we want to go. And the other part is, what if you've had 3 violations over a 30-year time period versus 3 in the last year, or whatever it is? And again, that number of violations just doesn't make sense from several factors.
No, thank you. That makes sense. Yeah.
Okay. Any other thoughts on civil penalties? Okay, we're almost through this then. Opportunity for hearing pretty much builds on our existing rules, pretty much lays out all of the different sets for the hearing. There are a couple of new components within that. But like I said, most of it is existing. And really what it comes down to is that we're notifying them that they have the right to appeal. So anytime we're doing these actions, the proposed actions, we have to include a notice of their right to appeal. And then this spells out what needs to be in an appeal. It clarifies that they have to actually specify the factual matters or claims and defenses that they're going to bring up. And then it spells out the 20 days for being able to do that. And some of the new things were things like being able to, if it's an entity or organization, actually, spelling out that needs to come from their legal counsel. Our Department of Justice is going to be kind of clearing that language up, but that was kind of an initial placeholder. And we've seen that where, like, we have multiple parties, or a corporation will get one employee that might just say, I want to an appeal. And it's like, well, but you don't represent that entity. And so you need to make sure you have that authorized legal representative in there. So just trying to clarify some of those. And then also being able to set out where things go if you don't make your claim, which basically moves straight to a final order. So, any questions on the hearing process? No. All right. So the last section, again, pretty much all existing, is kind of it's an interesting process that everything else we've talked about is really more of administrative, which is a civil process, but it is really bringing out and pointing out that we can also go through civil processes through the court system, where effectively either the department can initiate it or any person. So we have a lot of watchdog groups on the coastline. If any of them had seen something that the agency wasn't moving forward with, what they would do within these rules is basically say, hey, department, we're giving you 60-day notice. We are going to put in, basically take the stuff that's in rule here, and we are going to be submitting it to the local court as a civil matter to abate this public nuisance. And that 60-day notice allows us basically the opportunity to interact with them and look at maybe going through our administrative process. And so it just brings all that through, talks about what needs to be in the court filing. It also includes double and treble damages if we go that route, if what happens. So there's kind of a series of elements. And again, this is all pretty much from our current rules and statutes. And then a few things that we brought over into rule relate to, again, with civil remedies, to go back to the liens, as well as the money going to the Ocean Shore dedicated account. So we have those things. So yeah, pretty much just cleaned that up a little bit and brought it all into one place. Any questions on civil abatement? Great. Well, let's see. I know we're a little bit past time, but I appreciate the great dialogue we had, especially on the temporary prohibition. That's some good feedback. I am going to stop sharing here for a second, and I do have another topic for us to discuss, and I just need to get set up on that.
Do we want to take a 5-minute break?
Yeah,
Just to,
let's do that.
Move between. We won't do the full break,
Absolutely.
but we'll do a 5-minute break and come back at 3:33. Thanks. Okay, well, it is 3:33, so I think we're back and we are on to the fee introduction part of the meeting. So, Kevin, do you want to take that portion away?
Absolutely. So, as you all noticed, I did not share any rule language with you, and that is because we don't have anything to share right now, other than our existing rules. So the kind of background, I know we talked about this in the first RAC, but under our recent legislative change, we were given the opportunity to develop our fees by rule. As we kind of talked about it, this is the same slide you guys saw before. Under our current, we have no ability for adjustments over time, and it's a very simple calculation that doesn't cover our costs. And it was last updated at least in '99. So really, we've gotten to the point where our fees don't actually cover the costs. And so what we're hoping to do is find a way to really bring the fees equivalent to the application costs and um, be able to actually have them be commensurate with the type of review and pay our costs. So what does our existing rule say as context? Well, basically it's all based on construction value. And if your construction value is less than $2,500, it's a $400 fee. Generally speaking, other than remedial grading, there is not a project that comes in that's less than $2,500. You can't hardly fire up a piece of equipment and operate it on the ocean shore for that anymore. So most of ours goes under the calculation of $400 times 3% of the construction value over $2,500. The construction value has its own problems in being able to get that information from applicants, because it's not just the contractor doing the construction costs, it's the design, it's the planting, monitoring, all those other kind of costs built into that. We've been trying to bring that around. It's really difficult to get that information and apply that consistently. And as I said, it really the fee calculation penalizes the large projects, or I should say, the more expensive the project, it gets a higher penalty. And what we end up seeing from that is, and these numbers were early numbers I ran. They actually, I will say, they have changed, but not significantly. So if you see different numbers later on, I was just trying to get numbers in front of you guys. This was something I put together early on when we were looking at for the legislation. But our costs for an application, we kind of broke it down as a team, and we went through and we looked at all the different applications we get, and I broke down looking at this kind of table here as a snapshot of all of the different stages we look at during a permit. How much time do we kind of spend on an average application, and who all's involved in that within the department, and the cost that we incur, and at least try to come up with an initial number, and something that was workable to at least present this to the legislature, as far as this is our best guess on what we get. Part of that being some of these complex ones, we only get a cut 1 to 2 a year, or 1 to 3 on as kind of the range over the last few years. And that's what this table is just kind of looking at, these different application types. And so you can see that most of our projects are actually up in the simplest, but a lot of our time can be spent on these larger projects. But that also, over time, these completed alteration processes down here would be these average and complex for the most part, and you can see how they change from year to year. And so trying to kind of look at numbers across the way, we were really balanced with what do we do. And so we looked at it from more of this, what does it take to process in a simple app or an application from simple to complex, and kind of came up with these ranges. But if you'll notice here in particular, we had permit application fees that were $100,000 plus for some of the complex ones, and we had others that were 400. And I'll even put the disclaimer on that. We had others that were 0. And that's why there's there's some caveats to this, is basically starting in October of 24, we stopped basically waiving permit fees for a lot of the small projects that we were getting. The department had read some of the waiving of the permit requirements to include fees, but then in early 24, we had some dialogue with our council that that actually was not a correct read to waive the fees, and that we needed to actually be getting fees. So we've been able to correct some of that. That's where this $400 comes from, is starting to get those on those simplest. But if you notice, even on that, when we look at kind of what our cost was, they're not covering our fees. So what we did is went to the legislature. We asked them to give us the ability to update the statute to allow us to create our own fees. So what you see on the screen in front of you is what our new statute looks like. And basically, part of the application, they have to pay applicable fees. This is for the general authorization. There's also one for the individual or for the alteration applications too. But it's telling us we're going to adopt fees for any improvement permits, which are standard alteration permits, emergency, and general authorizations. So those are kind of the three tasks that we've been assigned as we work through this. And then as we look into how we develop that fee, that's what 7B here goes at, is it's really looking at recovery of our administrative costs. And then also applicant, public benefit, the construction value, something we can look at, the impact of the ocean shore, and then and that would be related to those project types, and then the mitigation costs associated with damage. And so building all of that kind of into our fees and how we structure that. So what I'm going to do is kind of walk you through some different examples and then show you kind of what those are. Then I want to get your feedback on kind of what trajectory should I take when I develop something? Kind of, are any of these models worth it? Is there a new model? What should we do? Because this is pretty open, and it does have some a lot of good parameters. It gives us a pretty blank slate to work from. So one of the projects I looked at was down in California. Their coastal development permits, and I have taken on this screen. There's a lot of content here, but really tried to boil down what's in their document to kind of what's relevant to ours, because they also do basically subdivisions and residential developments, commercial developments, that type of thing. And I stripped those fees out and put in the ones that would actually apply to, in particular, shoreline protection type projects, but because that was the most applicable. So they have a base, or their fees do have an annual adjustment rate built in, and it's based on the California Consumer Price Index. And then they also have a multiplier for after the fact permits or applications that include after the fact work, have a multiplier of 5 added to them. And so it's that disincentive of do the work first and ask for forgiveness later. They have a base fee for waivers, and then they have their administrative permit. And from what I could tell, pretty much, unless you're doing one of the small projects, you're everybody's paying that as their base fee. Then they have the additional fees. And these additional fees range from basically just under 5,000 to over almost 400,000 for a $100 million more project cost. And then they also have a fee related to the amount of volume you're going to work on, from 50 yards or less, no fee, up to 200,000 cubic yards or more is basically 16 grand. And then they have a call out for additional costs for these large, unusual, controversial projects that basically they can, the commission can add that on and require reimbursement for those, which I thought was an interesting concept on that, and a little bit of a black box that you have to guess what you might get added. Then they also covered amendments, which they have an immaterial and a material amendment. So basically, it's effectively half the cost for an immaterial amendment and of the base fee. And then if it's a material amendment, it's 50% of all the fees to do an amendment. And they do have a fee related to filing an appeal, which I thought was a really interesting concept that I'd never seen before. And then they also have a basically half the administrative permit for emergencies. Department of State Lands has just recently updated their fees. They kind of what I understand from talking with one of their staff in a presentation that staff member presented was the land board looked at their costs, the program costs, and basically said, hey, that's, we're effectively subsidizing permittees. We're not recouping most of our costs. By 2030, we want you to be recouping most of the costs for the program. And so they've gone into a 5-year incremental rollout starting January 1st of 26 going through 2030. They require the base fee to be due at the time of submission and other fees to be submitted before permit issuance, which is also kind of what I'm proposing. That way we're not effectively burdening applicants with mitigation fees or permit management fees if they do get a denial. And so it's really more of what does it cost to apply, recoup those costs, or what does it cost to review the application, and then have any other costs come in later. Their structure is based more on project type and complexity, not the project cost or the volumes, where you saw the California Coastal Commission was based kind of more on the project costs and the volume. They have it laid out to where you have general authorizations, which we're going to have general authorizations, again, have a smaller fee. I'm just going to kind of use a 2030 as the starting point. You'll see that I use that in the other ones just to kind of have consistency of where we would want to be with fees. They're doing it as a rollout so that it's not a shock to the system. Ours, any increase is going to be a shock to the system. So I'd kind of recommend we just kind of move to where we need to be, and then we reevaluate as we go, or we build in a CPI and kind of inflationary index along the way. But they do have a just under $700 GA fee, and then they do have a revised, or if you transfer it to somebody else, they do have a fee related to that as well. What's more interesting is within their removal fill permits, which would be analogous to our alteration permits, is that they have a base application fee they have base application fee, and then they have their permit issuance fee is based on a tier, but their bases are set on if it's a for-profit project or a not-for-profit project, which I don't see as necessarily being something we would do on the ocean shore. We do have kind of profit-generating activities, but it's not the same as like what Department of State Lands might be seeing, where it's a subdivision development on wetlands or something like that, where a commercial operator is coming in, they want to develop the land, they're generating the revenue off of that. Versus a landowner. So most of ours, I think, would fit more in this type A if we had to kind of layer that out. And then, so they have the base fee of, we'll call it $1,000. And then they have these tiers, and I've done a very superficial summary of what they are, but effectively tier 1 is kind of those habitat, environmentally friendly projects. And then as you move down to tier 5, those are going to be really complex reviews, having wetland mitigation, having large permanent impacts, things of that nature. And so it's really a continuum down through. And it's an interesting concept that could apply to the ocean shore. And I think we do have some potential tiers. Maybe we don't have 5, but I think we could use that approach as one model to work on. And then they do have other fees too, renewal fees. If you need to do a variance of, basically this in-water work and these modifications are when you're looking at some of their conditions. The in-water work is an ODFW type work window in which you can actually avoid some of the aquatic species. And so there is a cost involved with getting those reviewed and coordinated between the departments to get that done. So that's kind of how they set theirs up. And then I had kind of put together a really conceptual model before I had looked at those other agencies, just more of what I kind of thought might work, and really looking at moving away from construction value and looking more at the activity type, applicant type, landowner versus public benefit, and the impacts, and kind of trying to figure out how do we kind of base those back to what the impact and the project effects are on the ocean shore, using the base fee to really cover the agency costs for the application review. And the reason I'm kind of moving that route and proposing kind of similar to what we see on the other applications is in our time period here, we've had a permit that was denied where the applicant paid almost $50,000 for their application fee because it included that construction value, and it ended up being denied. Where it probably didn't cost, or it didn't cost us that $50,000 to run that process through the process. And so how do you build that in so it's fair and equitable to all these applicants? And so trying to move more to that. Yes, they might have, let's just say, still paid a $50,000, but maybe that initial part is only a few $1,000s, and then the rest of it comes right before we issue the permit once a affirmative permit decision is being tendered. And then basically making that permit fee due before issuance. And so that would include their mitigation. It would include any sort of just compensation. And so that's what we'll look at this permit fee here. So how did I break that down? Kind of looking at these very similar to like what DSL was looking at, right? Where we have kind of a base fee that for these simpler projects, which usually for application review, the general authorizations should be simpler. Same with the emergency authorizations from a review. And then the alteration permits are going to be more time intensive. And so that's why you see the higher application fee. What I have down here in this estimate is kind of what we were able to, for the application review, kind of come up with for what time it takes. And then also the amendments, kind of looking at that as a kind of almost basically a 50% of the cost for doing some sort of amendment, because there is review and coordination that goes into those. Pre-application meeting is a new thing for us. Just when we ran the numbers, I mean, when we look at it from simple to complex, there's a wide range. Most of our pre-applications are probably going to be I would say the estimate's going to be more in that 200 to probably 1,000 to 2,000. It just depends on how much we're having to go on site, travel, do background research. This 8,000 is really based more on it was a cable landing, the more recent cable landing, where we had multiple public meetings, multiple site visits by various staff. I mean, it was pretty intense. So just kind of throwing those estimates out there so you can see where that lands. And then the concept here, I don't have numbers in here, but is like, the questions I have for you are things like, do we do any sort of difference for the applicant type? Like if it's a public entity, do we give them a discount? I mean, it still costs our department the same amount of money to process an application, but is there a discount? And what I mean by the public minus and the private plus is like, does the private pay more than the public entity or not? Same thing or we could look at the public benefit of the project. So again, if it's a public access way onto the ocean shore, that's directly supporting the mission of the ocean shore and the department. So should those project types have a lower application fee because there is a little subsidy versus not? Again, they're still the same cost to us. So those are some kind of broader questions. Charlie, I saw your hand went up. Did you want to ask a question here before I move on?
No, I can wait till you're finished. I
Okay.
think there's a lot you've covered here, and I had feedback on several things, so I can wait.
Yeah, no, absolutely. I'm like I said, the whole last slide, I'm trying to get the background and then let you guys run with it because a lot of questions. So, and then the permit fee, what we would look at, and so I've got a couple of just placeholders here, is things like there is a cost to monitoring the projects, permit compliance, permit closeout, those kinds of things. And in many cases, that's actually more time consuming and cost the department more than doing the permit review. And so having this based on the project type, actually having a permit fee that comes in. And so like one of the things I have EC for erosion control of emergency permits, you might wonder, well, why would you look at something like 10,000? Well, emergency permits are probably one of the most time consuming and complex and enforcement heavy projects and authorizations we ever do. And we should have some of that potentially go back to if they come in for a permit, some of that could be potentially moved forward toward that, but we need some way of recovering those costs. And so that was one idea, is that you have, hey, if this is an erosion control emergency permit, well, maybe we have something like a higher permit fee. Same thing with the alteration permits, having it based on the project type. Things like maybe an access is at 1,200, but erosion control might be at like more of a 22,000, again, because there's a lot of site visits, staff time, whatever being put on that on the complicated ones. So again, potentially a range in there. Then we've got these other three columns, which fit into some of the parameters that you saw in that statute. And one you did, this just compensation. I will have a slide that has more information on what our current rule talks about just compensation. But basically for pipelines and cables and natural product removal, the statute requires us to have the applicant pay just compensation. We currently have that in rule, but we don't actually have a number. We don't know what that should be or how we should even calculate that. So that'll be something that I would be looking for this group as we move forward to kind of help define. And then mitigation, and I have these CM as compensatory mitigation. And so one is for use and one is for damage. And so things like, one of the things that we've kind of internally brought up was things like having a mitigation payment based on the construction aspect of it. How many miles do you plan to drive up and down the beach for, hauling, and or how many times a day do you want to do that? Or how many square feet are you taking up of the beach with temporary construction activities for how many days? Those kinds of things of that temporary use, because there is an impact to the public for that. And that partly becomes the consideration both for the impacts to the public use, but it also becomes a negotiating factor of, it actually can be cheaper to do these things from the upland, and it's actually that is the preferred alternative. So if you can actually avoid the impacts to the ocean shore, then this number is going to be much lower. But if you come in and you propose something that is a much higher impact project, then there is a compensation coming back to the public versus effectively what becomes a subsidy of free open area for staging equipment use. And then the damage is, the commensurate mitigation for damage is, again, this is something that we will probably have to have potentially have another work group on to go to figure this out more, but concepts on what are the impacts, right? One of the things brought up is like, if you put in shoreline protection and you fill X number of square feet of beach, is there a number that should be compensated to the public, and what is that number, right? Or loss of use by the public, or damage to habitats or other resources. And so that would all be built into this permit fee that would be due before we issue the permit. So what does that kind of look like? I threw all of them, these three scenarios kind of together, put kind of what I have is our best estimate on kind of what the cost ranges might be. And when you look at these, it's interesting to see the similarities, but also differences between them. I kind of took some hypotheticals from each of these and tried my best to apply the fees based on the information I had in front of me to kind of use that same simpler, average, and complex projects, as well as the amendments and emergencies and general authorizations. And that's just kind of what it looks like. And what I thought interesting is some of these, like the complex ones, DSL's numbers and our number, or my numbers, were very similar. They're a little low compared to California. And some of them, it was comparable to California, but not to DSL. And so it's really interesting to kind of look at these from that standpoint. But again, these are all just concepts, how we could apply them. And so what I really want to do is really kind of run through your thoughts on this and kind of how we do the fee structure and the tiering. And I'll come back to the slide. I'm going to jump forward so you see what else I have. And then pre-application fees, and even things like there was a 1994 recommendation for fees for the geologic reports for peer reviews. And then then my last slide is more of about compensatory mitigation as a fee and what we need to bring in. And I have the current rule related to just compensation. So I'm going to jump back to this slide because this is where I want your feedback. I really am hoping to get some direction on kind of where should we head, and are any of those examples that I gave just perfect or horrible? Don't even go that route. And we will have another session where I'll actually bring some proposals to you to review, including the rules with those. But like I said, right now, I'm just trying to figure out what direction do I head. So I have, seven or eight questions on here. Please feel free to answer any of those that are jumping up at you. We don't need to necessarily go in order on those. Charlie, go for it.
Total Ocean Shores program cost on the first question is my general thought. I like I like the tiering system of DSL, and I also like the activity type. I don't necessarily think that the same type distinction might. I think your example of public versus private is better than a for-profit versus nonprofit kind of activity type, if you will. But I actually think there's maybe more to that. I think to like how uses of the ocean shore are permitted through like events and things, and there's also some discretion for the agency with respect to, the applicant and the type of whether you're doing a beach cleanup or whether you're doing donuts with a Toyota for a Toyota commercial. You have discretion there in how you apply fees on that. And so I do like type and I do like tier. I think at a minimum, though, the base fee should definitely cover all of the program costs up front. I also think there's this lifespan of the project where fees come in. I don't like all the fee stuff of California as much, and how that's structured, but I do think that there's this idea that projects are done and you raise the issue of monitoring and maintenance, repair, the next homeowner, all the sort of lifetime cost to the agency in that permitted project. And so I do think that there should be some scalable fee around sort of the lifetime of the project, which is still something I'm a little unclear on because we don't have lifespans associated with projects and permits. But those are my general reactions and thoughts. I'm not sure about the for-profit versus nonprofit thing. I think I like the public, private, and scaling that based on type. Other types might be a tier.
Okay, thank you. Megan.
Yeah, I was just going to agree with Charlie on the lifetime piece. I don't know if it's just for private projects, but also public projects. It seems like a barrier to some of the natural nature-based feature implementation is having to reapply for permits and reapply for fees and whatever, and not have the funding for that. I mean, like to do maintenance on these projects, which is a really important piece. So I don't really know the best way of handling that, but if there was a way to allow for some of these projects to have some built-in maintenance fees that are covered, like for your review with OPRD covered up front, so they don't have to find money for it again later. That might limit or like reduce some barriers to implementation.
Okay. So that'd be reducing barriers to kind of the ongoing maintenance, right?
Yeah, which is a really important piece of the, at least the nature-based solutions, having this ability to do maintenance and not have it be like a barrier for even doing the project in the first place.
And I'm just thinking out loud here because I think it's an interesting prospect of, so if we built that in as part of our review, did all of that for nature-based, and then maybe had, I mean, we've been talking about having like repair permits for within our general authorizations for certain types of repairs. And so if we were to, if I'm hearing you right, if we had an individual or kind of a full alteration application come in, had the fees built on that kind of captures what those long-term costs are, but then maybe we have a general authorization for non-structural nature-based maintenance and repair with a minimal fee, that could go a long ways to keeping those viable. Is that kind of, would that be a potential option?
Yeah, I think
Okay.
that sounds like what I was saying. Yeah.
Okay. Yeah, no, that's something we can definitely look into. That's a good point. Diana.
So I think you guys definitely need to cover your program costs. As far as the appeals, I'm surprised that there's not a charge for that, if I'm understanding you correctly. In Cannon Beach, to put in an appeal application, it's $1,000. I was wondering about if there can be some incentive in a reduction of fees for people who are doing, nature-based or soft structure erosion control measures. I'm just wondering in this larger conversation what the state can do to support that type of innovation. So if you are willing to take on, you are goal 18 eligible, but you would like to take an approach that is less damaging to the beach. Is there a way to incentivize that? And then, piggybacking on Megan, we know that these soft structures are going to need more repair more often. And I know that you have built in where you can, roll over some of these approvals. But, as Megan was saying, is if there was a way that they have to have that plan, their maintenance plan, just like the state of Washington does. So it's a part of the initial application, and there are triggers for when maintenance needs to occur, and the funding is in place, either an escrow or a bond, or however you do that. And then when those triggers hit, it's already been evaluated, and you guys can handle that revision process more easily. So I guess that's kind of a couple pieces on that as far as supporting soft structure solutions. And then you mentioned that the construction costs, it was hard to get all of those numbers. And two thoughts on that. One is, it seems to me that there should be clear guidance on what is required, like, what is a revegetation plan and a maintenance plan and a monitoring plan. And then the application is not complete until you have all of those pieces. So, I mean, I'm sure I'm not telling you anything that you haven't thought about, but, and also it's like, we have vegetative riprap, but there's people who haven't revegetated after storms for 2 years. So have they met that condition? I would say no, but I don't know that I can point, to anywhere in the rules that supports that. And then as far as pre-application fees, it seems like you guys really want to have a pre-application process. And so I think you should, you need, that's going to take your time and effort. So of course you need to be compensated for that. And the geo report review, and the specific design review, I think that's critical. And absolutely, I mean, I think you guys need to have somebody on retainer who can be looking at that from the perspective of what's best for the shoreline. And I think that's paramount. So that's all.
All right, Felicia.
Yeah, so just to follow up on previous, comments, especially related to, nature-based versus structural protection, I was thinking like maybe as DSL did, like under the alteration permit, you can have maybe 2 types of permits, type A, in the case of like nature-based solutions, type, and so the cost would be lower, and type B would be, if you have structural protection, like the cost would be a little higher. So that could be a way to integrate that. And I was thinking it would be interesting also to see for the different tier, like DSL has been doing, but in terms of like, public benefit and applicants. So I wonder if it should be a way to do some, like you did for your table with like applicant type and public benefit. Is there a way to transform that into maybe tiers for like the different like permits? Yeah, I feel like there is still a lot of ways to play around with all the different values and different ways you could do it, but that's what I wanted to add so far.
Thank you. Megan?
I like what Diana said about the natural nature-based features. And I also just, with the review process, whatever you call it, engineering review or whatever it is, whoever is on contract or retainer, I think it's just really important that they have background in coastal processes, and we should figure out what that means for Oregon.
Yeah, and I think it's a broader dialogue that's outside OPRD as well. I mean, we need to engage larger, and I think that's what that 1994 recommendation had. But it's kind of, and I think a lot of the counties actually have in their code, or at least, and there definitely is in the model code from DLCD, to have that same kind of, we can require that. And I think at minimum, that's where I was thinking, is at least having it as we can require. Because I think what would be interesting is if we get something set up like that, is how do we get the funds to, whether that's somebody, a dedicated staff position at an agency, whether that's a contract, position. I have no idea. That's, like I said, beyond where we're at. It's something that I know is brought up, and since we're getting the application, we would be one of the areas that would be getting a fee associated with that. And so yeah, definitely not going to be solved in this rulemaking, but at least we could have the fee built in. So okay, Cameron.
Maybe it's just my confusion, but it looks like is there a possibility that the 2 of these questions are kind of overlapping: adjustments for public versus private applicant and adjustments for public benefit. It sounds like and maybe it is a true assumption, that if a public applicant is applying for a project, it's going to be for a public benefit. A public applicant is not going to apply to something that's just going to be another piece of riprap. But maybe that's not necessarily a good assumption. And so I'm wondering if, maybe those 2 should actually be separated, that we should have an adjustment for a public applicant versus a private applicant, but also an adjustment for a project that's going to be public benefit. Because a public applicant could, like the Corps might, the U.S. Army Corps of Engineers just apply for, another riprap project, and they're a public applicant, but the project is not a public benefit project necessarily. So, is there a way to reflect that possibility that things might need to be dealt with on both levels of the applicant and the project itself?
I think it could be any bring up. I probably should have said ocean shore, public ocean shore benefit or so. Then because when I said that, I was thinking like, is it a public access or is it habitat? Because you're absolutely right. You look at, I mean, I'll use an example that's in front of us now. I mean, you have Highway 101 and there's a proposal to put armoring on the beach. Well, it is for a public benefit for the 101, but it's to a detriment of the ocean shore. And so it's not a public benefit of the ocean shore. So yeah, it was probably more of my quick putting the terminology down, that I probably should have had ocean shore benefit in there. So public ocean shore benefit. So that was kind of where I was, at least my question, that's where I was going. But you bring up a very valid point that you can have those public entities that may not be doing something that's necessarily benefiting all the public. It's so that I think that's a good thing to consider, and I will make that clarity in at least in my head, that that's an ocean shore benefit, not just public benefit in general.
Okay, I just think that both of those things there should be adjustments based on both of those. But I guess a subsidiary question is a public applicant, it can be anything from, the local bird watching group to the Army Corps of Engineers. And their budget and the likelihood of what they want to do is probably going to be very different. So should there be any adjustment in the rules concerning the type or the size of the public applicant?
I would say that would get fairly complicated. And how do you judge that? How do you price it? Because I'll go back to, the cost for us to review is the same. It's based on I'll say more on the project type and complexity, not the applicant. And so I think I understand where you're coming from, but that becomes a really hard piece, because I hear from county governments all the time, I don't have any money to do this, and maybe they're wanting to do public access. Well, they may be a large county from like the coastal perspective, but they may not have any money dedicated or available for doing public access. So they're trying to do it. So they're wanting to get that fee waived, where, maybe a nonprofit's gone out and got a grant and they actually have more money than that county does, because they went and specifically found funds for a project. And so that would become a really challenging factor to apply consistently or fairly. And I'm not really sure how I would go to that one. So just a thought.
Okay, I'm not stuck on it. I just am, noting the fact that
Yeah.
public applicants is a very large category that covers a wide range.
Mm-hmm. Absolutely.
And should that be dealt with in some way? I'm not sure.
Yeah. Okay. Charlie.
Yeah, I wanted to plus up Diana's comments and Megan's as well, around lifespan of the project, maintenance in particular. I think that's a pretty big one for both structural and non-structural. I think I know that we're talking a lot more about the non-structural and the nature-based, but I mean, as we're seeing, riprap does fail and does need maintenance, and I do think that it's important that we're kind of looking in both directions on that. Um, Obviously, more specificity is necessary in the non-structural, but there's a lot unknown right now, and there's a lot of not good guidance, or there's a lot of bringing another rock. I can think of a project right now. And so I think the more on the front end, like Diana said, that we can help guide applicants in the right direction, the better. I love incentives for nature-based. We say we want non-structural over structural, so incentives are great. I still believe the agency should recoup their cost in those. I wouldn't think that those would be a huge cost to the agency, or wouldn't want them to be. I think they should be treated like any other permit application in that sense. But in other places and where other fees, I think obviously there's less of a cost to the ocean shore, and potentially a nature-based solution. And so that's a good example of where a fee structure could be adjusted. And to your point, before with Cameron there, I do think some specificity about where that impact and where the public benefit is or isn't, and the ocean shore being specific about that, because you're right. We can make a lot of cases for a lot of projects that would to permit on the ocean shore of public benefit that might not be that the same thing. So, and I don't know if we're talking about mitigation right now. I have a lot of opinions on that. You've incorporated a really good representation and idea of that. I'm still nervous about how something like that goes into place, but I do appreciate the work that you put up front on that.
Yeah, and I mean, and it's something that's now clearly defined in statute too, which is, I mean, I think we've always had kind of we'll call it on-site mitigation that you could do. But now we have the compensatory kind of built into the statute too, which will be a good thing. And I do think that the mitigation is going to have a further dialogue. The question is, now do we build something in, even structurally now, even if it's not specifically defined, to at least allow us to kind of go down that path as necessary. And so I can jump to the next slide whenever we're ready, because that's more about mitigation. But I think just to kind of build on it, Charlie, I think the way I've kind of tied compensatory mitigation up is it's more applicant proposed right now, with the understanding that that gets the placeholder in, and then hopefully over the next, I'll say, year or two, we can do a phase 2 rulemaking where we talk specifically about mitigation and what does that look like, and have an actual, mitigation, formal mitigation program of some sort. So yeah, this is the foot in the door, make it more where people understand that it's not just a one-way street of. So John.
Yeah, on the pre-application fee, just also kind of from recent experience, once you start charging for pre-application meetings, they're going to want to do a lot more with you before they submit a request for a pre-application meeting. Something else you can do is a consultation fee. So you might just think about it from the standpoint of your staff costs a certain amount of time. You may charge them a very kind of a compensatory amount to get an hour of staff time just to discuss the options, alternatives, including maybe talk about things that don't involve riprap, and and maybe lay out some options for protecting the property that doesn't involve an application for a shoreline protective structure. That's assuming they get to you early enough, and before they are actually in the emergency stage. But yeah, having two different types. Yes, you got an application ready to go. We want to talk to you before you submit it, and you have a pre-application meeting. But also, I don't know, new property owner, they have no idea what they're getting into. Yes, you absolutely can have a conversation with you. You have to pay a small fee, but we'll talk to you for an hour and give you all your options. So two different opportunities for a potential applicant anyway, and then you're recouping your staff time as a result of that. And then the other thing, as far as fee structure for having a peer review, for both geology and engineering, there are two separate disciplines there. So however you do that, but absolutely, anytime you've got technical documents and you want them checked, I don't know what you would establish for criteria for saying, hey, I need to have somebody take a look at this, or how you would want to do that, or if you'd actually want to just kind of make a standard, hey, we do have somebody third party check your work when you submit it to us, just to give us some feedback, and do that every time, however you do that. But I think you'll implement it rationally no matter what. So, but those are my only thoughts.
Thank you. Rhiannon.
Yeah, I think that it would behoove you to have some limitations set for pre-application meetings, and what kind of time period that looks like, how many meetings are going to be allowed. what type of information can be shared during those meetings. I know that I know pre-application meetings haven't been like set in rule before, but that is a common practice that you guys do. And that oftentimes people will want like definitive answers for projects that they haven't even submitted an application for. And sometimes there's a lot of back and forth, as you know, we've discussed this, and then the project doesn't even move forward. They don't do an application or they withdraw an application. And so there's like, you know, weeks to months of time spent on one project that ultimately doesn't even move forward. So I think having some sort of limitations would be helpful.
Okay. That's good. Okay, so let's see, Diana, you're up. And we're starting to get close to the end of our time, so this might be the last one.
So John had mentioned having somebody from your group meet with people beforehand and run through options. And that, again, I mentioned this before, but Washington has what they call the Shore Friendly program, and they have coastal engineers that meet with property owners. And it's supported by the state, so there's no cost to the property owners. It sounds like, you know, we're not there, we would need to charge them, but that expert is looking specifically at their site and running through options with them so that they know in what direction to begin their process of building their application and what isn't you know, going to fly at the state level. So I wonder if that, and obviously, you know, I wonder if that isn't something that could be looked at and would help things go a little more smoothly. And then Washington's Ecology has a geotech, a geoengineer on staff. And so anyone in Washington at a planning department that gets an application can ask for that review or specific pieces of that review. And then they also can ask for a coastal engineer, like Megan was saying. There, you know, right now our rules only discuss geotech, geoengineer, and that's leaving off, you know, this incredible other part of it, as Megan said. So if there is a way to incorporate a coastal engineer into these rules and have everyone understand that, you know, all of this expertise is needed to build something that's going to be in everyone's best interest. And then I also wanted to just say, so when you say any adjustments to public benefit, I feel like, you know, a soft structure falls into that public benefit. So thank you.
Oh, that's a good point. Okay, I know we've got just a couple minutes. I just want to set this up for something to think about, and I know mitigation, we could talk for a full day on it. I'm going to jump down to the just compensation because mitigation is really, I said there are a couple things I brought up earlier. We could spend a lot of time. My thought is to build something in to where it's like, hey, if you propose to do this, here's kind of what we're looking at. I'd love to have your thoughts emailed to me on kind of what you think might work for a framework for mitigation. And we can talk about it at the next meeting too, or at one of our subsequent meetings here. But what we had in for just compensation, as I said, in our rules currently, we have natural product and pipeline and conduits. And basically what we have laid out there is that the department's going to get paid from the applicant or by the permittee a flat fee plus reporting, percentage not to exceed a certain percent of gross revenues, a fee rate per measure, and administrative costs. And it's some combination of those, right? And then the same thing with pipelines and conduits, it's the length, where, you know, where's the surface, or where is it coming out of the surface? Are there other impacts along the way? And part of me sees these other impacts, like the potential impacts to scenic landforms, fish and wildlife recreation. That to me fits more into the actual compensatory mitigation than it does in just compensation. And this does have some factors in here, like benefits that will accrue to the public from the operation. So again, we're using that to maybe soften that. And so it's really a weird collection that we're put in the current rules. And yet, you know, we have these kind of ups and downs, but then at no point shall it be less than the department's administrative costs. Well, if just compensation is only paying the administrative costs, then is it really just compensation if it's paying for the permit. So it's kind of a weird, the way the rules are written right now, I'll be blunt, we haven't really been able to implement them. Somebody made a decision for just compensation at one point in time for pipelines and conduits as $10,000, and that's what we've kind of moved forward on the last few. For even these large Amazon and other, projects, they're also getting easements from the Department of State Lands, which is going from, the territorial sea or through the territorial sea. And so there's this, it's kind of like, how do you boil all these things together? So I wanted to frame those up and share them with you because it is something to think about as we're having this discussion. Like I said, I'm going to punt this to our next meeting. We'll put this on the end of it after we've gone through the actual section that we're reviewing, because again, this will be multiple conversations, I think. So I just wanted to frame that up. Charlie, go for it.
I assume you're working with DSL on this stuff, or given they're in a fee restructuring analysis. Well, there was that directive in that bill years ago, which led to the rulemaking advisory committee and the work that's kind of underway right now as well. So I just want to make sure that, like, are we hand in hand with that, or I felt like all of that problem was that Parks was very separate and ended the line on all of that work, and a lot of our goal was to make Parks more integrated into that, or at least be able to recoup cost associated with that.
Laurel is working more direct on that. If Laurel, if you want to chime in, but I will say a lot of what we've been seeing is up to the ocean shore. And so we're trying to kind of push back on some of that of like, can we have like the easements and other things where, there's this kind of weird jurisdictional overlap with DSL on, we'll call it on the submersible lands portion of it. And I won't get into that now, but yeah, it's kind of a weird scenario. I don't, Laurel, if you want to add anything, but the answer is generally no, I have not. But part of that is we really haven't got dug into this yet to see which way we even want to go. Because like even natural product removal, we haven't done natural product removal in decades. It just happens to exist in statute. It hasn't been removed. But apparently there used to be gravel mining and sand mining on the ocean shore. And so that's where that really came from. But that doesn't happen anymore. So
Kevin, did you want me to
go for it?
Yeah, we haven't had the first RAC meeting for the DSL rulemaking for what you're talking about, Charlie, but I have had a chance to take a look at their initial draft, and I've been working with their staff on coordination on that topic. But what they're working on right now is their easements. So they have some guidance from their DOJ on their, ownership rights for the easement component. So I think it's just an ongoing coordination issue that we're not going to solve right now at the end of this meeting, but it is on our radar, and we are working with DSL staff on trying to coordinate the two things.
Okay. I just can think of several projects in the last decade or so that cost Parks a lot of money based on a lack of an ability to be structured on fees in those areas. So I'm looking out for the agency here and how we best do this.
Yeah, I think that's part of what Kevin's asking is for this portion that is the ocean shore permitting component is separate from the easement. So right now we just have the 10,000 that we've been applying.
And that is based on absolutely nothing from what we can tell. It was just somebody came up with a number that said 10,000 sounds good. And that was kind of, well, that's all we've been able to recover.
It looks like we're at time, and we have another meeting scheduled for next Friday. So we will get you all the information sent out by early next week with the agenda and meeting materials for next Friday's meeting. And we'll keep following up on this discussion next week.
Thank you, everybody.
Thank you all.